All right, looks like we are clear to proceed. Again, thank you and welcome to Courtroom 6. I'm going to ask each side to introduce the participating team members, starting with prosecution.
Good afternoon. My name is Hannah Feeney, and I will be delivering the opening statement and conducting the direct examination of Alex Cifuentes, as well as the cross-examination of Avery Becker.
Thank you, counsel.
Good evening. My name is Anna Carrington. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen.
Thank you.
Good evening. My name is Annika Buchin. I'll be conducting the direct examination of Kyle Kuzak, the cross-examination of Taylor Perkins, as well as presenting the closing argument. May our witnesses please introduce themselves?
Thank you, counsel.
Good evening. My name is Grace Oliver, and I am Alex Cifuentes.
Thank you.
Good evening. My name is Kate Malloy, and I am Detective Jordan Markowitz.
Thank you.
Good evening. My name is Pilar Melendez, and I am Kyle Kuzak.
Thank you for the prosecution team and for the defense.
Good afternoon, Your Honor, and members of the jury. My name is Amanda Brockler, and along with my co-counsel, we represent Avery Becker in today's case. Today, I will be performing the direct of Professor Van Owen, as well as the cross of Detective Markowitz, and the closing arguments of today's case.
Thank you, counsel.
Good afternoon, Your Honor. My name is Grant Rose, and today I'll be doing the cross-examination of Alex Cifuentes and the direct examination of Taylor Perkins.
Thank you.
Good afternoon, Your Honor. My name is Jacob Aragon. Today I'll be giving the opening statement, as well as the direct examination of Avery Becker and the cross-examination of Kyle Kuzak. Your Honor, at this time, permission for the witnesses to introduce themselves.
Granted. Love to hear from them.
Good afternoon, Your Honor. My name is Amanda Jin, and I am Blake Van Owen.
Good evening, Your Honor. My name is Hannah Patel, and I am Taylor Perkins.
Welcome. Thank you.
Good evening, Your Honor. My name is Delaney Boston, and I'm Avery Becker.
Thank you. At this point, I believe it's time for swearing of the team members. So team members, if you could raise your right hand. Do you all promise that the presentations that you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
And for witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
And scoring panelists, if I could ask you to raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Thank you, everyone. I appreciate your cooperation with that. Both sides have announced ready to proceed, and so we shall begin. Opening statement for the prosecution.
Before that, Your Honor, we have a few preliminary matters.
All right.
Let the record reflect that the pronouns for all prosecution witnesses, as well as the prosecution roster, which is available for download by all jury members, have been posted in the chat.
So noted.
And prior to today's trial, the prosecution would like to verify a couple of the mechanisms of this online trial. Specifically, the prosecution will be admitting exhibits pursuant to rule, as outlined in Rule 7.4. As such, any exhibits displayed on the screen will be assumed to not be seen by the jury until specifically asked to publish. We will only ask to publish when we intend to show it to the jury following admission.
Of course, thank you. Anything else?
Yes, Your Honor. Since exhibits are assumed to be displayed outside Since displayed exhibits are assumed to not be seen by the jury, would Your Honor like us to ask permission to display exhibits on the screen or simply to let the record reflect such?
Why don't you ask permission?
Yes, Your Honor. May we also have permission to zoom into or otherwise modify exhibits for purposes of clarity?
Yes, but when you're doing that, if you could make that clear, I would appreciate it.
Yes, Your Honor. Furthermore, while each of the attorneys and witnesses have made attempts to be in a space with the best internet capabilities possible, if at any point you are unable to see or hear us, feel free to interrupt us.
Absolutely, and I would also invite any of the scoring panelists to give such an indication to me through the chat box if they are having difficulty seeing or hearing things, if the connection goes bad.
Your Honor, for the record, all witnesses are present for the testimony in today's trial, and none may be sequestered pursuant to Rule 5.3.1.
Correct. Yes.
Can the court? Very sorry.
Go ahead.
Can the court clarify whether it intends to constructively read the jury instructions before or after closing arguments?
Constructively before closing arguments.
At this time, we reserve any remaining time from our closing argument for rebuttal.
All right.
And
I'll make a note of that.
Yes, Your Honor. Finally, we are confirming for the court and the jury that the complaint, stipulations, and all preliminary matters have been incorporated into the record.
Yes, of course.
At this time, we are ready to proceed to opening statements.
All right. Anything preliminary from the defense?
Your Honor, we just ask that because of internet, as our opposing counsel talked on, that if there's any latency or if someone cuts out or anything like that during their testimony, that the time be paused until they can come back and answer.
I think that's appropriate and so ordered. And our timekeeper can give us an indication of that if we run into that situation. So far, everything, at least on my end, has been just fine. Hopefully it is for all of you as well.
Yes, Your Honor. Thank you. That's everything.
Anything further? All right. With that, opening statement from the prosecution, please.
Yes, Your Honor. Before I begin, can Your Honor see and hear me all right?
Yes.
May it please the court?
Please proceed.
A mask can't hide the truth, and the truth is in the map, messages, and motive. It was Friday, March 6th, 2020. Mackenzie Brackman, a local defense attorney, was alone in his home on South Flower Street when a masked intruder tried to enter his front door, but it was locked. The Ring doorbell security system was set off. The intruder went around to the back of the residence, and in a panic, the victim grabbed a kitchen knife to defend himself. When the defendant entered through the back door, a struggle quickly ensued over that knife. The defendant wrestled the knife away from the victim before stabbing him in the back. That's when the defendant ran. The victim tried to follow to the front door before pulling the knife out and rapidly bleeding to death. Mackenzie Brackman died in that home invasion, but that intruder's mask, Avery Becker's mask, can't hide the truth. And the truth is in the map, messages, and motive. After a thorough investigation, we charged Avery Becker with 2 crimes: murder in the first degree and second-degree burglary of a dwelling. But to understand murder in the first degree, first we have to talk about second-degree burglary of a dwelling. It says that on or about March 6, 2020, Avery Becker broke an entrance into or unlawfully entered a dwelling with the intent to commit criminal mischief, which simply means to damage another person's property. Now, let's talk about first-degree murder. The judge will tell you that Avery Becker is guilty of first-degree murder if Mackenzie Brackman was killed by anyone, while Avery Becker was committing second-degree burglary or in immediate flight from the scene. We will meet our burden and prove Avery Becker guilty of both charges because a mask can't hide the truth. And the truth is in the map, messages, and motive. Let's break that down. A map. You will hear from Detective Jordan Markowitz, the lead investigator in today's case. She will tell you about call detail records that put the defendant's phone at the victim's house at the time of his murder. You will hear how the phone movements show the defendant staying there long enough to commit the crime. Speaking of phones, pay close attention to the messages the defendant sent to Alex Cifuentes, a teammate of Miss Becker. Ms. Cifuentes will tell you how this kind of mischief wasn't out of the ordinary for the defendant. After all, she had vandalized the victim's car only days before. You will hear how in these text messages, the defendant confessed to planning to commit this crime just before Mr. Brackman's home was broken into and he was murdered. Now, we've talked about the map, we've talked about the messages. Let's talk about the motive. You might be asking yourself, why would a high school student commit such a crime? You will hear how the victim was the defendant's mock trial coach. You will hear all about the bad blood between them, and you will hear how upset the defendant got when she was kicked off the mock trial team. You will hear from Kyle Kuzak, a crime scene reconstructionist who worked with Detective Markowitz on this case. And she will tell you how the crime scene is consistent with the defendant's motive and how this was a burglary gone wrong. Just like what Miss Becker threatened to do in her text to Miss Cifuentes. But for everything you'll hear today, you won't hear that the defendant intentionally killed the victim, because that's not what happened, and it's not what we charged the defendant with committing. Instead, this was a burglary gone wrong, and Mackenzie Brackman died as a result. That is first-degree murder. A mask can't hide the truth, and the truth is in the map, messages, and motive. After you hear all of the evidence, it will be clear that Avery Becker committed this crime. And that is when my co-counsel, Ms. Buchin, will ask you to deliver justice for the victim and find Avery Becker guilty of both charges. Thank you.
Thank you, counsel. Defense, opening statement.
Yes, Your Honor. And before I begin, can everyone see me and hear me all right?
Court can.
Perfect. Avery Becker did not break in to Mr. Brackman's home. Avery Becker did not kill Mr. Brackman. Avery Becker is not guilty. You see, Avery Becker was a former high school student. She had the passion for law, and she was a decorated mock trial competitor. On top of that, she is a community member, a daughter, and a good friend. In fact, on March 6th, she spent the entire day with her friend Taylor Perkins. They went to the mall, the Fry Shack, and home. They never saw Mr. Brackman, and they never talked to Mr. Brackman. And she certainly never did the things the prosecution wants you to believe that she did. Avery Becker now finds herself being targeted in a criminal investigation. An investigation that was rushed, sloppy, and lacks any real evidence tying Avery Becker to the scene of the crime. Because Avery Becker is not guilty. The prosecution is charging Avery Becker with 2 charges. They're charging her with burglary in the 2nd degree and murder in the 1st degree. But let me remind you, the prosecution carries a burden in this case today. They must prove to you each and every element beyond a reasonable doubt. It is the highest burden in our legal system, meaning they must prove to you each element. And if you walk away with not one element being proved, then you must find Avery Becker not guilty. If you find any reasonable doubt at all, then you must find Avery Becker not guilty. The prosecution will not meet their burden in this case. Today, the prosecution will leave you with 3 questions that go unanswered. 1, does the prosecution explain when this murder occurred? And as we will have to tell you, they can't and won't. 2, does the prosecution ignore other reasonable alternate suspects? And as we will have to tell you, they did. And 3, does the prosecution have any evidence at all tying Avery Becker to the scene of the murder? And as we will have to tell you again, they don't. You'll hear from 2 prosecution investigators today. You'll hear from Detective Markowitz, the lead investigator on this case, and she will tell you this case begins and ends with Avery Becker. This was their first and only lead they found. Next, you'll hear from Detective Kuzak, who reconstructs the crime scene. The prosecution has 2 detectives at the crime scene and no physical evidence to tie Avery Becker to the scene of the crime. These investigators do not collect DNA, fingerprints, blood samples, hair follicles, clothing fibers, or any other form of evidence that could connect anyone to this crime. So after not finding any DNA or any fingerprint leads on the crime scene because they did not collect this evidence, the prosecution's next best option was to, of course, check out the high school mock trial team, the team that the victim coached for, to find possible suspects. The prosecution is asking you to take leaps, unreasonable leaps, to conclusions in this case that they do not have the facts to back up. Members of the jury, you should demand the prosecution show you evidence tying Avery Becker to the scene of the crime. Any evidence at all. They have the burden in this case. That is their burden and their burden alone. They brought the charges. Now they have the responsibility of proving them. And as you'll see today, they're not able to do that. Members of the jury, the prosecution's case is full of holes. And you'll be able to see each and every one of those holes. This was a rushed investigation. This was a rush to judgment. Avery Becker is not guilty. Thank you.
Thank you, counsel. Prosecution, you may call your first witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Thank you. You'll recall that you are already sworn, Mr. Ms. Cifuentes.
Yes, Your Honor.
Counsel, you may proceed.
Before I begin, can Your Honor see and hear me all right?
Yes. And I would ask the jurors if any of them are having an issue to raise a question in the chat box. I don't see any, so counsel, you may proceed.
Yes, Your Honor. Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Alex Cifuentes, and I'm a senior this year at Colorado High School.
How are you feeling about testifying here today, Ms. Cifuentes?
Nervous. I just want justice for my mock trial coach, Mr. Brackman. It's been really hard knowing that he's gone and that I'd have to tell a jury about what Avery did.
Now, we'll get back to that in a second, but first, could you tell us a little bit about Mr. Brackman?
Well, Mr. Brackman was an incredible attorney and an even better mock trial coach. He seemed to really care about everyone on the team doing their best.
And based on your observations and perceptions, did everyone on the team have a good relationship with Mr. Brackman?
No. Most people liked him, but his relationship with my teammate, Avery Becker, wasn't as great.
How so?
Well, they would argue at almost every single practice. Avery didn't do things the way coach wanted, and coach would call Avery out on it. It got so bad that she was kicked off the team 2 separate times.
Your Honor, at this time, I ask the court to order the defendant to turn on their camera for purposes of identification.
So ordered.
Do you see the defendant here in court today?
Yes, I do.
Could you please identify her by an article of clothing and the title of her video?
Yes, she has on glasses and a jacket and a white shirt on underneath. And the title of her video is Avery Becker.
Your Honor, let the record reflect that the witness has identified the defendant subject to cross-examination.
The record shall so reflect.
Also, at this time, the defendant may turn their camera off.
Please do so. Thank you.
Ms. Cifuentes, you mentioned arguments between Ms. Becker and Mr. Brackman. Were there any such arguments in the days leading up to Mr. Brackman's murder?
Yes, there was actually one 3 days before on that Tuesday. They were arguing about the competition that happened that weekend.
Tell us about that.
Well, Coach was telling Avery that she needed to put in more work before the state tournament. And this made Avery really upset. She actually grabbed one of the Sharpies that we were using to write down notes with and stormed outside. Later, I found out that she wrote on the coach's car. She was kicked off the team that same night.
To the best of your knowledge, did Ms. Becker ever attempt to get back on the mock trial team?
She did. She actually texted me shortly after the car incident asking if I'd be willing to talk to the coach for her.
Now, I'd like to shift the focus to what happened after Mr. Brackman was murdered. Were you ever asked to come in for an interview by Detective Markowitz?
Yes, I was.
About what specifically?
About the text that I was just telling you about.
Did you preserve these texts for Detective Markowitz?
I did. Unfortunately, when I went to the interview, I forgot my phone, but the detective asked me to send her screenshots of the text.
Your Honor, may I have permission to display Exhibit 14?
Yes.
Ms. Cifuentes, what is this exhibit?
These are the texts that I was just telling you about, the ones from Avery.
Just to clarify, whose messages are in green and whose are in gray?
The ones in green are the ones that I was sending to Avery, and the ones in gray are the ones that Avery was sending back to me.
And are these texts a fair and accurate depiction of your conversation with the defendant?
Yes, they are.
Your Honor, at this time, I move to admit Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. I object to hearsay.
Response.
Yes, Your Honor. This is not hearsay pursuant to Rule 801. The statements in gray are made by Ms. Becker and are therefore a statement of a party opponent under Rule 801D2, and the statements in green made by Ms. Cifuentes are not being offered for the truth of the matter asserted, but rather to provide context for Ms. Becker's statements.
Reply.
Your Honor, we do not concede that these texts came from the defendant as they are in dispute. Thus, they do not fall under the admission by party opponent. There's been no proper foundation laid to prove that they are from my client, and therefore this is hearsay.
May I respond?
Please go ahead.
These texts have been authenticated to be from Avery Becker pursuant to Rule 901B1 through testimony of a witness with knowledge. As Ms. Cifuentes, who is the one who received these texts, has testified that they did in fact come from Avery Becker, sufficient foundation has been laid to show that these texts did come from Avery Becker. And as such, the statements in gray are not hearsay pursuant to Rule 801D2, as they are a statement of a party opponent.
Any brief reply?
Your Honor, although the witness claims that these text messages came from Avery Becker, they have not been authenticated. There are no timestamps on these text messages. These could have been from a year ago. Therefore, once again, my objection still stands. This is hearsay.
The court will overrule the objection, finding sufficient foundation has been laid and that these are properly admitted as statements of a party opponent. Counsel, you may proceed.
May I publish to the jury?
Yes.
Ms. Fuentes, I'd like to draw your attention to the second text from Ms. Becker. What is this text referencing?
Well, this is Avery telling me that she got kicked off the team and asking if I'd be willing to talk to the coach to help her get back.
How did the conversation proceed from there?
Well, I told her that I wasn't really sure anyone could change the coach's mind, especially after what Avery had done to his car. And that's when she showed her true colors.
What do you mean?
Well, she went crazy. As you can see, she threatens that if Brackman is still upset about what Avery did to his car, then he's going to be really upset when he sees what Avery does to his house.
And did the defendant ever explain what she meant by this?
Yes, I obviously asked her, and she told me that she was going to wait until the coach was at work and then break in and trash his house.
Objection, Your Honor. Cumulative. The document speaks for itself.
May I respond?
Of course.
Your Honor, this is not cumulative, or this is not unduly cumulative pursuant to Rule 403. Yes, while this exhibit has been admitted, Ms. Cifuentes' testimony helps the jury to understand these texts by providing context for the statements.
Brief reply.
Your Honor, I understand that opposing counsel wants to talk about the contents of these text messages, but they are verbatim reading these text messages back. Once this is published to the jury, they can feel free to read this on their own, but this line of questioning should not be asked.
I'll allow the testimony, but would encourage counsel to be efficient and move along.
Yes, Your Honor. Ms. Cifuentes, were you finished with your answer?
Well, I was just saying that Avery threatened to break in and trash Mr. Brackman's house.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Cifuentes.
Good afternoon.
Before we talk about your time on the mock drill team, I want to understand your relationship with Avery Becker a little bit better. According to you, you and Ms. Becker had a very close relationship?
We did, before she murdered Mr. Brackman.
Right, so that's a yes then?
Yes, as I just said.
Right, but you only really spent time together at mock trial practice.
Mostly, yeah. It was kind of hard to hang out during school. She's a year older than me.
Even though you claim to be one of Avery's best friends, you would ask Coach Brackman on several occasions why he put up with Avery's attitude.
Yeah, I mean, even though she was my friend at one point, I still didn't like the way she treated people.
So that is a yes then?
Yes, as I just said.
Perfect. And after Avery rode on Coach Brackman's car, you believe Coach Brackman should have pressed criminal charges against Avery.
Well, Avery broke the law, so yeah.
Even though you claim she was one of your closest friends.
Just because at one point I thought she was my friend doesn't mean I don't think she should have consequences for the things she does.
Mr. Fuentes, I'm sorry. I know you want to be able to explain yourself and you'll have plenty of time to do that on redirect examination. I was just asking for a simple yes or no response. So you claim she was one of your closest friends, correct?
At one point I did, not anymore.
Going back to mock trial, you feel that it's a slap in the face when somebody who doesn't work hard still gets the best attorney award?
It's pretty disheartening, yeah.
Especially because you feel you were equally skilled as team members.
Yeah, her, me, the entire team.
Right. So you were glad when Avery Becker was kicked off the team?
No.
Well, you were excited about the larger role you would have with Avery gone?
I wouldn't have had any role with Avery gone. With her leaving, we would have been disqualified from state.
Right, but you do think that the team is better off without Avery?
After she would graduate, yeah, I think the team would be better with hard workers.
Right, so better off without Avery.
Yes, as I said.
You have been kicked off the team. Let's talk about this text conversation you claim to have had with Avery Becker. You claim that Avery Becker texted you that she'd planned to go to Coach Brackman's house and trash the place?
Yes, that's what Avery threatened to do.
Yet you never contacted the police after receiving this alleged text message.
Not within the couple days before Brackman was murdered. And afterward, I wasn't entirely sure what happened to Brackman, so I didn't know.
Right, so you never contacted the police after receiving the messages, correct?
No, like I just said.
To report that somebody was planning on committing a burglary on your beloved coach's house?
Well, I thought that Avery would sleep on it, decide it was a stupid idea, and wouldn't act on it.
Exactly, you agree it was an act that could have potentially put Coach Brackman in danger.
Yeah,
And you
I
adored
didn't think
Coach
she would go through with it.
Oh, I'm sorry for cutting you off there.
It's okay.
And you adored Coach Brackman.
I didn't adore him. I looked up to him. I mean, I wanted to go into law. He was a great attorney.
Right, well, in other words, you would have never done anything that would put him in danger.
No, of course not.
Yet the very first time you reported those text messages to law enforcement was after Coach Brackman was murdered.
Yeah, I didn't know what happened. That I only knew that Brackman was killed. I didn't know how it happened.
And only after Detective Markowitz reached out to you.
Yes.
How convenient. No further questions, Your Honor. Thank you.
Any redirect?
Yes, Your Honor, briefly.
Please proceed.
Ms. Cifuentes, you were asked a lot about your relationship with Ms. Becker. Did you ever bear any resentment towards Ms. Becker for her performance in mock trial?
No, of course not. She was my teammate.
And when you received the text messages seen in Exhibit 14, did you want to believe that Avery Becker would commit such a crime?
No, I thought I knew her. I didn't think she would do it, but now I know.
Thank you, Your Honor. I have no further questions.
Any recross?
No recross needed, Your Honor. Thank you.
All right. Counsel for the prosecution, you may call your next witness.
The prosecution calls Detective Jordan Markowitz to the stand.
Thank you. Detective Markowitz, you are still under oath, I'll remind you.
Before I begin, can Your Honor hear and see me all right?
I can, and if any of the scoring panelists are having issues, please raise something in the text. But I am seeing none, so counsel, you may proceed.
Yes, Your Honor. Good evening. Would you please introduce yourself to the jury?
Good evening. My name is Detective Jordan Markowitz, and I'm a homicide detective with the DPD.
How long have you been involved in law enforcement?
I've been with the DPD for the past 13 years, 7 of which I've been a detective.
Do you have any unique knowledge or skills that you relied on in this investigation?
Yes. In this investigation, I relied heavily on my knowledge in crime scene investigation, specifically regarding cell phones and their technology.
Do you have any certifications in this field?
I do. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
Have you used this knowledge and skill in other cases you've investigated?
Absolutely, all the time. Given how prevalent cell phones and their data are in today's society, I find myself constantly using this type of information.
Your Honor, at this time, I ask that the court recognizes Detective Jordan Markowitz as an expert in crime scene investigation with an emphasis in the forensic analysis of cell phones and call detail records.
Any objection?
Permission of voir dire, Your Honor.
Briefly.
Good afternoon, Detective Markowitz. I just have a few quick questions for you.
Of course.
You have a lot of training and education in the field of cell phone data and analysis.
That's correct.
But fair to say you're not a crime scene reconstruction expert.
No, I'm not. That's Kyle Cusack's job.
You're also not a forensic scientist.
No, I'm not.
Or a medical examiner.
No, I'm not.
In fact, you don't have any medical training at all.
I'm a detective, not a doctor.
Your area of expertise is really just around cell phone data.
No, cell phone data and crime scene investigation. I am a detective.
Judge, the defense does not object to this witness being accepted as an expert in the field of crime scene investigation and the cell phone expertise that they have, but we just want to make sure that their expert testimony is limited just to the field that they're providing, that they're not providing improper expert opinions in the areas of DNA analysis, blood spatter analysis, and the like.
Any response?
Yes, Your Honor. Detective Markowitz does not plan to elicit any opinions that are not within her specific field.
All right, so the court will recognize Detective Markowitz as an expert under Rule 702 on cell phone and crime scene investigation. Counsel for the defense, if you believe that the expert is straying from those fields, I'm sure I'll hear from you. Counsel for prosecution, you may proceed.
Yes, Your Honor. How did you become involved in this case, Detective?
I originally received a request for dispatch on March 6, 2020, requesting a detective. And I arrived at the scene of the crime, which was 444 South Flower Street in Colorado, at approximately 2:20 p.m.
Could you describe the scene when you first arrived?
Of course. When I first arrived, the first thing I took note of was that the victim's body was face down, just inside the doorway, and the door to the residence was open. I also took note of the fact that there was a large kitchen knife on the ground near the victim's body.
So what did you do first?
Well, first, I called in a couple of people to help with the investigation. The first team I called in was our forensics team, and then I called in Kyle Kuzak, our crime scene reconstructionist.
Since Ms. Kuzak was the one who actually reconstructed the crime scene, we'll talk to her more about the details of the scene. But what was the next step in your investigation?
The next step in my investigation was to gain access to the victim, in today's case, Mackenzie Brackman's cell phone. And this was to see if there would be any details that were important to the investigation.
Did you find anything significant on Mr. Brackman's phone?
I did. I actually found two pieces of evidence that were significant.
What were those two pieces of evidence?
The first piece of evidence I found is that the victim had a Ring doorbell app on his phone. And from that, I was able to download videos of the suspect both entering and leaving the residence. And the second piece of information I found was that the victim had a lot of recent contact with a mock trial team. So that gave me my first lead to follow up on.
Now, before we talk about the Ring doorbell videos, was there any DNA found at the scene?
No, there was not.
Now, about the Ring doorbell videos, did you preserve each of those videos for trials?
Yes, I did.
Your Honor, may my trial technician have permission to display exhibits 10 through 13 on the screen?
Yes, permission granted.
And at this time, may my trial technician have permission to zoom in on these exhibits so that my witness may properly identify them?
Yes, go ahead.
Do you recognize these, Detective Markowitz?
Yes, I do.
What are they?
These are links to the Ring doorbell videos that I was just describing.
Are these links fair and accurate representations of the Ring doorbell videos that you collected?
Yes, they are. I actually recognize these links because I reviewed them before trial today.
Your Honor, at this time, I move for the admission of exhibits 10 through 13 into evidence.
Any objection?
No, Your Honor.
Admitted.
Thank you, and we can come back to those on Ms. Kuzak's testimony. Now, Detective Markowitz, you mentioned another lead found on the victim's phone. Could you tell us about that?
Yes. Like I was saying, the victim had a lot of recent contact with a mock trial team. So I reached out to a couple of his students. I first spoke with Alex Cifuentes, and when I was speaking to her, it immediately became clear to me that she had some information that would be pertinent to my case. So I asked her to come on down to the station for an interview.
Did you learn anything from that interview?
Yes, I did.
What did you learn?
I learned that Ms. Cifuentes had recently been in contact with the defendant in today's case, Avery Becker, that Avery Becker was telling her of plans to want to break in and
Objection, Your Honor, hearsay. This is all testimony that this witness learned from Ms. Cifuentes.
Fonz?
Yes, Your Honor. These text messages have already been admitted into evidence. Therefore, they are no longer out of court statements being offered to prove the truth of the matter asserted. However, if you do find that they are hearsay, we are not offering this to prove the truth of the matter asserted. Rather, we are offering this to show why Detective Markowitz took the next step in her investigation, which was to try and get into contact with Avery Becker.
Reply.
Your Honor, I'm not only referring to the text messages in this case, but everything that this witness is talking about from their interview with Ms. Cifuentes. All of that information is hearsay about Avery Becker's past on the team and what she was just prompted to answer.
Although the testimony may be hearsay, experts can rely on hearsay in the course of developing their opinions, so the court will allow it.
Yes, Your Honor. Were you finished with your answer, Detective Markowitz?
No. Like I was saying, Ms. Cifuentes had been speaking with the defendant in today's case, and the defendant had claimed to want to break in and trash the victim's home.
Your Honor, permission to publish previously admitted Exhibit 14 to the jury.
Any objection?
None, Your Honor, it's admitted.
Go right ahead.
Now, Detective Markowitz, earlier we heard Alex Cifuentes talk about these text messages, but how did they impact your investigation?
I'm so glad you asked. These text messages provided him an important window into why Avery Becker may have wanted to commit this crime. Furthermore, they were consistent with the evidence we had gathered at the crime scene and helped us to really corroborate our theory of what was going on.
Thank you. Exhibit 14 is no longer needed. Excuse me. Now, Detective Markowitz, based on the information in these text messages, what was the next step in your investigation?
The next step in my investigation was to reach out to Avery Becker to try to gain access to her cell phone, not only to corroborate the validity of those texts, but also to gain knowledge about her whereabouts on the day in question.
Were you able to gain access to Avery Becker's cell phone?
Unfortunately, no. We were informed that she was no longer in possession of her cell phone.
So without her cell phone, was there any other way you could find out where the defendant was at the time of the homicide?
Yes, luckily. I subpoenaed for Avery Becker's call detail records for March 6, 2020. We'll just call them CDRs for short.
What is a call detail record?
A CDR tells me the location of a cell tower that a person's phone connects to at any given point when they receive a digital communication, such as a call or a text. Based on that, I can pinpoint the approximate location of a person's phone.
Using call detail records, were you able to figure out where Avery Becker was at the time of the homicide?
Yes, actually. And there were 2 maps that were prepared to help the jury visualize what all of this really means.
Your Honor, permission for my trial technician to display exhibits 15 and 16 on the screen.
Any objection?
None, Your Honor.
Please proceed.
Do you recognize these exhibits, Detective Markowitz?
Yes, I do.
What are they?
Exhibit 15 is that map that I was just talking about of Avery Becker's call detail records, or CDRs, from March 6, 2020. And Exhibit 16 is that same map, but it also has a potential route that the defendant could have taken to get to the victim's home.
Are these fair and accurate representations of the defendant's location based on the data you collected?
Yes, they are.
Your Honor, at this time, I move for the admission of exhibits 15 and 16 into evidence.
Any objection?
No, Your Honor.
Admitted.
Permission to publish to the jury?
Granted.
Now, Detective Markowitz, using these exhibits, can you explain to the jury the route that matches both the time and location of the defendant's phone?
Of course. As you can see, the defendant's phone begins in the upper shaded region. This is the first tower that the defendant's phone connected to, and it pinged this tower 1 time. Then you can see it connects to a tower that is between the defendant's home and the victim's home. It also pings this tower 1 time. And lastly, it ends up in the bottom tower. This encompasses the area of the victim's home, and it pings this tower 4 times.
What does this mean?
To a reasonable degree of scientific certainty, that means that the defendant's cell phone was at the victim's home for 12 minutes approximately during the time that the crime took place.
Thank you. These exhibits are no longer needed. Detective Markowitz, based on your investigation and in your expert opinion, was Avery Becker involved in the break-in that led to the death of Mackenzie Brackman?
Yes, based on my investigation and in my expert opinion, Avery Becker went to Mackenzie Brackman's home, and during the course of that intrusion, Mackenzie Brackman was killed by Avery Becker.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Good afternoon again, Detective.
Good afternoon.
As a detective, especially a lead detective, you know that it's important to do a thorough investigation.
That's absolutely correct.
To follow all appropriate leads.
Yes.
And to identify and collect all relevant evidence.
Oh, absolutely.
So now let's talk about what you did and did not do in your investigation. In this case, we know that the intruder tried entering through the front door.
That's correct.
But ended up entering through the back door.
Yes, as you can see in the Ring doorbell videos.
Yet you did not have those doors checked for fingerprints.
We did, but there were no fingerprints on the doors.
And you did not have those doors swabbed for DNA.
We did, but there was no DNA found. This is consistent with the suspect wearing gloves and a disguise, as is shown in the videos.
Speaking of DNA, you testified that you found blood drops in the dining area.
That's correct.
Yet you did not have those tested for DNA either.
We did. It was the my apologies, the victim's DNA in today's case.
It is your testimony today that you had those blood droplets tested for DNA?
Yes.
In this case, you made a statement?
Yes, I did.
And in that statement, you were complete?
Yes, I was.
And thorough?
Yes.
If there's anything that you found in your report, it'd be located in that statement?
Anything of relevance to the case today.
And you signed the back of that statement?
Yes, I did.
Detective, nowhere in your statement does it say that you tested those blood droplets for DNA.
That wasn't relevant, counsel, as we found that it was the victim's DNA, and it didn't help to support any findings in today's case. So, no, I didn't include it in my affidavit.
So the first time that we're ever hearing this fact is in court today?
That is correct, yes.
Okay. You didn't even collect that blood as evidence, though.
There's no way to collect blood as evidence. So we can test it, but not collect it.
You claim that you took photographs of this blood.
That's correct.
But this jury won't get to see those.
Unfortunately, that evidence was corrupted in today's case.
That's right, you lost the evidence.
We didn't lose it. An SD card was corrupted. There's nothing that can be done about that, really.
That's not the only thing that fell apart during your investigation. Let's talk about leads. As a detective, you should never try and go or take the case where you think it should go, correct?
I take the case where the evidence leads me.
Right, you follow the evidence and you go where it takes you.
Exactly.
Good police work requires you to follow up on all possible leads.
That's correct.
And in this case, the evidence showed that the victim was a somewhat well-known criminal defense attorney.
That is correct, yes.
That fact made you worry that this murder could be the work of a disgruntled ex-client.
Originally, that was one of my suspicions. However, the facts of this case do not support that.
And that it was highly unlikely that the victim's mock trial activity had anything to do with it.
Like I said, originally that was a theory that we had, but ultimately the facts led to Avery Becker.
But you did nothing to look into the victim's former clients.
No, that's not true, counsel.
Again, detective, you made a statement in this case?
Yes.
And you were super thorough in that statement?
I included anything of relevance to my investigation.
And you would agree that you mentioned nowhere in your statement that you reached out to the former list of clients for Mackenzie Brackman.
Exactly, because that lead didn't take us anywhere. It didn't prove anything in today's case.
Again, Detective, this is the first time we are ever hearing this fact is in court today, correct?
That is correct because it wasn't relevant. That was not a lead. Ultimately, that is not where the facts led us.
Now, how many students are on that mock trial team, Detective?
I believe around 8.
Yet, as an officer, you attended a police academy, correct?
That's correct.
And in that academy, they teach you report writing skills.
Yes, they do.
That it's important to document everything,
That is correct.
including what witnesses you spoke to
Yes.
and what those witnesses told you.
Again, yes.
This is important because, as you know, the district attorney relies on your report in determining what charges to bring.
You're absolutely correct.
You also know that defense attorneys, like myself, also rely upon those reports to prepare a case.
Yes.
So what you put in your report matters.
Yes, that's correct.
And what you fail to include in your report also matters.
I'm sorry, I don't follow your line of questioning.
What you fail to include in your report also matters, Detective, because that could be highly relevant evidence to the case.
I wouldn't not include relevant evidence in my report.
Now, in this case, your report only mentions Alex Cifuentes, Avery Becker, and Taylor Perkins as mock trial students.
Yes, those are the students who are relevant to today's case.
But you also spoke to a student by the name of Brandon Digby,
That's correct.
although that interview is nowhere in your report.
Again, it didn't lead to anything that would be relevant to my investigation, so I didn't include it.
You also spoke to another student by the name of Josiah Mitchell.
That's correct.
And again, the entire interview is not documented in your report.
Like I said, I only included the relevant evidence.
Now, let's talk about what other evidence you failed to collect and document. You never downloaded the text message data from Alex Cifuentes' phone.
No, I did not.
Yet you have training and experience in data recovery from cell phones.
Yes, I do.
And as a detective for the past 7 years, you've downloaded the contents of literally hundreds of cell phones.
That's correct.
And Alex Cifuentes told you they had a text exchange with Avery Becker that almost amounted to a confession. Isn't that right, Detective?
Yes, and we've seen those text messages in court today.
And this evidence, for lack of a better term, was paramount in your case.
It was one piece of evidence that we considered, yes.
Well, it provided you with a motive for Avery Becker.
Yes, it did.
So you just had this high school student send you a screenshot of those texts.
In this case, the screenshots were sufficient to corroborate our findings.
Even though you just told us that the common course of action would be to download the contents of that phone.
That is not what I said. That is not always the common course of action. In today's case, the screenshots were sufficient.
To get an untampered record of the actual text messages, you would have to download the contents of that phone, though.
Not necessarily.
Your police department has the software to do so.
Yes.
And you personally have the training to execute that action.
That is correct.
But failed to do so.
I did not fail to do so, counsel. As I said, it was the text messages in this case were sufficient.
It's your opinion that Avery Becker was near the victim's house at the time of the murder.
Yes, that is my opinion.
So let's talk about when this murder occurred, because the time of the murder is extremely important in today's case. Isn't that right, Detective?
I'd say it is, yes.
Because the time of the murder is what makes the cell phone records relevant.
To a degree, yes.
And those are the only things that tie Avery Becker to the crime scene.
Those are not the only things. The cell phone records are not the only things now.
Now, we know that the first event that happens is a 911 call that comes in. What time does that 911 call get placed, Detective?
My apologies, I can't remember right now.
You're the lead detective in this case and you cannot tell us the timeline of this case?
I cannot give you the specific time of the 911 call right now, no.
And it's not documented in your report?
I'm not sure I remember.
You also have no idea what time the intruder entered the home?
It would have to be around the time that Avery Becker's phone began connecting to the cell tower that encompassed the Brackman residence.
Detective, I'm not talking about Avery Becker. I'm talking about the intruder detached from Miss Becker's cell phone records. You have no clue when the intruder entered the home.
Like I said, we do know because of Miss Becker's cell phone records.
You also have no clue when the intruder left the home for that matter.
Again, like I said, we do know because of Avery Becker's cell phone records.
Your ring videos do not have a timestamp.
No, they do not.
So the intruder could have entered the home around 12:45 p.m.? I don't know.
That's unlikely, counsel.
But they could have because you didn't document a time in your report, correct?
It is possible that that is when the intruder entered, but based on the rest of the facts of the case, it is highly unlikely.
But 12:45 p.m. is the time that you placed Avery Becker at her house.
Yes, it is.
Which is nowhere near the victim's home.
Again, counsel, I said it is highly unlikely that that is the time that the suspect entered the dwelling.
Thank you. No further questions.
Any redirect?
May I first inquire as to how much time I have remaining?
The prosecution has 8 minutes and 39 seconds remaining.
A brief redirect, Your Honor, and may I have a moment to rearrange my virtual courtroom?
Sure, you can have a moment.
Detective Markowitz, why didn't you include every single little detail in your report?
If I had included every lead I followed up on that led to nothing, my report would be pages and pages long, and it would not be relevant to the case. I included the facts in today's case that helped me come to the conclusion that I have provided today.
And what was that conclusion?
That Avery Becker broke into Mackenzie Brackman's home, and ultimately, Mackenzie Brackman died during the course of that intrusion.
Thank you, Your Honor. I have no further questions.
Any recross?
No, Your Honor.
Thank you. Witness may step down and the prosecution may call its next witness.
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand.
Kyle Kuzak, you'll recall that you are still under oath. Counsel, you may proceed.
Good evening. Please introduce yourself to the jury.
Good evening. My name is Kyle Kuzak. I'm a crime scene reconstructionist for the Denver Police Department. I'm commonly referred to as CSR for short.
A few minutes ago, Detective Markowitz established the different roles law enforcement had in this investigation. What was your role as the crime scene reconstructionist?
I work with the forensic team to put together all of the evidence found at the crime scene in order to determine how a crime occurred. To that end, I always follow a 5-step analysis process and make sure to document and memorialize as much as possible.
How long have you been involved in the field of crime scene reconstruction?
For approximately 19 years now, I've specialized in a variety of complex crime scenes. Those include homicides, burglaries, other property crimes, and even armed robberies.
Ms. Kuzak, are you certified to do what you do?
I am. I'm certified under the Colorado Bureau of Investigation.
Your Honor, at this time, I ask that the court recognizes Ms. Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Any objection?
Yes, Your Honor, brief voir dire.
I'll allow it.
Awesome. Good afternoon, Investigator Kuzak.
Good afternoon.
Just to be clear, you are not a police officer,
I am not.
so you've never gone through the police academy?
I am certified under the Colorado Bureau of Investigation, as I am a crime scene reconstructionist, not a police officer.
So that's a no.
No, because I am a crime scene reconstructionist.
You've never responded to a call for service as a patrol officer.
Not as a patrol officer, but when a crime scene investigator is needed, of course I go onto the scene.
But you've never led an investigation as a lead detective.
No, once again, I am a crime scene reconstructionist, not a lead detective or investigator.
Right. Likewise, you don't have any specific training in forensic cell phone data analysis.
That is correct.
You're not certified as a forensic cell phone data analyst.
No, as that is not relevant to my work as a reconstructionist.
Your entire basis for what you claim is your expertise is your certificate of crime scene reconstruction.
Yes, counsel, which needs endless amount of hours to complete and be certified under this field.
Which is also based on the 7-step methodology for event analysis.
That is correct.
And you claim you reliably apply those principles and methods to the facts and data in this case.
That is correct.
But how many steps did you follow in this case?
7, as it goes along with the 7-step methodology.
Is your testimony in this case that you followed 7 steps?
Yes, as they involve 5 main steps, counsel.
Your Honor, the defense objects to this witness being tendered in the field of crime scene reconstruction and investigation. First, this witness lacks the requisite training and experience required under Rule 702. They have no formal training in any areas of crime scene investigation. Their only basis of knowledge comes from a certificate and what they call crime scene reconstruction. But more importantly, in order for a witness to testify as an expert, they need to not only base their opinions on reliable scientific principles and the methods, but they must apply those same scientific methods to the case at hand. And this witness has already demonstrated through their voir dire that they did not follow the 7-step method. Therefore, their opinions are invalid.
Yes, Your Honor. Pursuant to Rule 702, Ms. Cusack should be qualified as an expert in crime scene reconstruction. Because in order to be qualified as an expert in today's case, you only need to have one of the following requirements: education, training, skill, knowledge. Ms. Cusack has testified to numerous qualifications. First and foremost, the fact that she testified to being a crime scene reconstructionist for over 19 years. That is not only skill, but that's also knowledge and training. Ms. Cusack also testified to having a certificate from the Colorado Bureau of Investigation. Although opposing counsel's voir dire went into whether she was a detective or the lead detective or had any deputy or patrol training, has no relevance or pertinence to Ms. Cusack's qualification as a crime scene reconstructionist in today's case. And therefore, Your Honor, under Rule 702, she is qualified, it can be qualified as an expert in today's case.
Counsel, an objection was also made as to the witness's methodology. Can you address that, please?
Yes, Your Honor. I believe opposing counsel was talking about the fact that they used 5 steps instead of 7, as opposing counsel testified to. Is that correct?
Yes,
that's
it is.
That's what I understood. Yes.
Your Honor, throughout if allowed to testify as an expert in today's case, Ms. Cusack will testify to her 5-step methodology and how that encompasses her 7 steps involved in conducting a crime scene reconstruction. Although Ms. Cusack didn't specifically testify to the exact 7 steps that she used, it does not mean that she didn't use them at all. Ms. Cusack has been tendered as an expert in crime scene reconstruction in countless other cases in her career, and therefore she should be tendered as one in today's case. And the methodology that she uses is consistent with expert testimony, with other experts in her field. If the court would like, I can ask if the 7 steps that she used is what experts in her field usually rely upon to formulate her conclusions, but based on the testimony made by Ms. Cusack, it's been sufficiently laid that this is something that she regularly relies upon.
Any reply?
Yes, Your Honor. In order for Investigator Cusack to be in line with the scientific community methodology, she needs to explicitly show that she follows the 7-step Tom Bevel for event analysis. As co-counselor has already said, she only showed 5. Therefore, directly, she's going against the scientific community standards when it comes to documenting methods in itself. Therefore, she should not be able to testify since she's going against it in its entirety.
Under Rule 702, the methodology is sufficient so long as it is reasonably reliable and the court finds that that foundation has been laid. In terms of qualifications and credentials, a witness will meet that standard if he or she qualifies by virtue of knowledge, training, education, or experience. And with respect to the field of crime scene reconstruction, that has been established, so the court will accept Ms. Cusack's testimony as an expert in crime scene reconstruction. Counsel, you may proceed.
Yes, Your Honor. Ms. Cusack, how did you first approach your crime scene reconstruction in today's case?
After collecting evidence and talking to the forensic team about the evidence that was collected, I also visited the scene of the homicide at 444 South Flower Street.
And what evidence did you rely on to formulate your conclusions?
Specifically, all of the photographs that were included in the case file, all of the police reports, all 4 of the Ring doorbell security system videos, as well as the police reports and the autopsy report as well.
Now, Your Honor, may I have permission for my trial technician to display exhibits 1 through 9 as well as exhibit 18 for purposes of admission?
Any objection?
No, Your Honor.
Permission granted. Please display.
Ms. Cusack, what are these exhibits?
Exhibits 1 through 4 from top left to right are all photographs of the victim. Exhibit 5 is a photograph of the knife next to the victim. Exhibit 6 is that same knife in a lab setting. And exhibits 7 through 9 are all photographs taken in the victim's residence, specifically the kitchen. And exhibit 18 are photographs of the scuff marks found at the rear door.
And are all of these photos accurate representations of the crime scene that you personally saw?
Yes, they are.
Your Honor, at this time, I move to admit exhibits 1 through 9 as well as exhibit 18 into evidence.
Any objection?
Yes, Your Honor. For all of the exhibits, this person did not take these photographs and was not at the initial crime scene, so she cannot attest their authenticity. And specifically for, it looks like exhibits 1 to, on the top row, these multiple murder photos are unfairly prejudicial over probative because they're all being entered at once. As you can see, these are very bloody documents of pictures of the deceased body and therefore are more prejudicial.
Any response?
Yes, Your Honor. If you mind, I'll start off with the photographs and the authenticity of that.
Please.
Pursuant to Rule 901, Ms. Cusack can authenticize these photos as she's a witness with knowledge. Ms. Cusack just testified to the fact that all of these photos are accurate representations of the crime scene that she saw. That she personally went to the crime scene and saw each and every one of these, and therefore can testify to the validity and the authenticity of said exhibits. Now, in regards to opposing counsel's objection of more prejudicial than probative and inflaming the passions of the jury, the people understand the opposing counsel's concern in displaying such gruesome images. However, as the prosecution in today's case, we have the burden of proof, which means that we have to prove every element beyond a reasonable doubt. And that includes discussing how Mackenzie Brackman was killed, especially because the manner in which Mr. Brackman was killed is at issue in today's case, as Professor Van Owen and Kyle Cusack have differing opinions. So it's crucial for the jury to see these exhibits in the context of Ms. Cusack's testimony so that they can get a better understanding and evaluate these pieces of evidence while hearing her testimony. And therefore, Your Honor, pursuant to Rule 403, this is not more prejudicial than probative, as the risk of unfair prejudice does not substantially outweigh the probative value of these exhibits. Like I just said, the probative value is extreme for these images, as they help the jury see how the crime was committed. And also, it's the people's position that it was Avery Becker who committed this crime. And therefore, showing the images of the bloody knife and the victim himself is not unfair in any way, shape, or form. And therefore, it's not unfair prejudice, pursuant to Rule 403.
Thank you, counsel. Any reply?
Yes, Your Honor. First, talking about the identification, again, I'd like to stress the idea that they call upon that this is a fair and accurate representation of the crime scene. However, Investigator Cusack was not there to collect them at the crime scene. The prosecution already had the opportunity to validate if these were a fair and accurate representation through Markowitz, that they failed to do that. Therefore, Investigator Cusack is not able to identify if these are authenticated or not. Moving on to the probative versus prejudicial value, entering all these exhibits at once caused it to be more prejudicial. If they really wanted to look at the probative value, we should enter 1 or 2 instead of all these prejudicial exhibits at once. Therefore, my objections both stand.
As to Rule 403, the standard is whether it is unfairly prejudicial. And I note that this is, in fact, a murder trial. And so the fact that there are bloody photographs should come as no surprise. As to the foundation, the court finds that sufficient foundation for the authenticity of these photographs has been laid. Counsel, you may proceed.
Yes. And Your Honor, permission to publish Exhibits 1 through 9, Exhibit 18, as well as Exhibits 10 through 13, which were admitted in the direct examination of Detective Markowitz.
Any objection to that?
No, Your Honor.
All right.
Now,
Go ahead.
Zach, let's start off by talking about Exhibits 10 through 12. Let's play Exhibit 10 for the jury. Now let's play Exhibit 11. And finally, Exhibit 12, please. Now, Ms. Kuzak, based on these 3 exhibits, can you briefly tell us what we just saw?
Of course. We just saw a perpetrator matching the general height and build of Avery Becker approach Mr. Brackman's front door, which was locked. That is why we see the perpetrator proceed to the south side of the residence, entering through the rear fence gate and proceeding into the backyard. And after that, in Exhibit 12, we see that the defendant is opening the sliding glass door and entering Mr. Brackman's residence.
Now, let's display Exhibits 8, 9, and 18. Now, Ms. Kuzak, using these exhibits, what happened after the intruder entered the residence?
Mr. Brackman was notified of the perpetrator's presence through the Ring doorbell security system. And therefore, Mr. Brackman armed himself with a knife, which came from the knife block pictured on your screen, Exhibit 8. After that, the perpetrator and Mr. Brackman encountered each other at the rear door. That is why those scuff marks in Exhibit 18 were left behind, as they struggled over that knife. The knife proceeded from the rear back door to approximately close to the kitchen table, where the plate was knocked down, as we see in Exhibit 9. And therefore, at some point, the perpetrator disarmed Mr. Brackman, and Mr. Brackman came at the perpetrator in a bear hug, and that is when the defendant stabbed the knife into Mr. Brackman's scapula.
Now, let's play Exhibit 13, and at the end of that video, let's display Exhibits 1, 2, and 5. So here's Exhibit 13. Now, let's display Exhibits 1, 2, and 5. Ms. Kuzak, can you briefly tell us what happened to Mackenzie Brackman based on these exhibits?
As we see in Exhibit 13, the defendant fled the scene moments after the homicide occurred. Mr. Brackman was found just inside the opening of the front door, as we see in Exhibit 1 and 2 on the left side of your screen. So Mr. Brackman followed the perpetrator out to the front door, and then he forcefully removed the knife from his scapula, therefore nicking his aorta, which culminated in rapid, heavy internal bleeding.
Your Honor, this is improper expert opinion. This witness can't opine or testify to how the anatomy was being ruptured and the results of that, since she is a crime scene reconstruction investigator.
Your response?
Yes, Your Honor. As Ms. Kuzak testified to earlier, she did look over the autopsy report and the evidence that she analyzed in order to come to her conclusion in today's case. So she does have the knowledge as to how Mr. Brackman died by looking at the autopsy report. Furthermore, Ms. Cusack has been tenured as an expert in crime scene reconstruction, and that's well within her qualifications to testify as to how Mackenzie Brackman died, as that is a crucial part of the crime scene reconstruction. And so Ms. Cusack can testify to how the knife nicked his aorta and led to him bleeding out, because that is the biggest part of her crime scene reconstruction. It's the climax of her reconstruction in today's case. And so Ms. Cusack, my apologies, Your Honor. And so Ms. Cusack should be able to testify, and it is within her qualifications to testify to that fact.
Any reply?
Your Honor, again, I do agree with the fact that this witness is able to opine and testify of how Mr. Brackman was murdered. However, she's talking about specific anatomy, and she's looking into how specifically the aorta was nicked and how this weapon caused that. That is outside of her realm of expertise, and she's not able to testify that, since she not only doesn't have proper foundation of how she knows medical terminology when it comes to this, and she's not tendered in that field.
Although this is close to the line, the witness as an expert is allowed to address materials on which the expert relied. Anatomy is part of the crime scene reconstruction field, and to the extent that the witness is relying on the autopsy report and makes clear that that's what she's doing, so there's no misunderstanding, the court will allow it.
Yes, Your Honor. Were you finished with your answer, Ms. Cusack?
I was not. As I was stating, the nicking of the aorta is what culminated in rapid, heavy bleeding internally, and that is what terminated Mr. Brackman's life. And obviously, this internal bleeding is portrayed in Exhibit 1 and 2, as we can all see.
Now, Ms. Cusack, briefly, is the evidence you analyzed consistent with Avery Becker committing this crime?
Absolutely.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. And before I begin, is it okay if I check the time to see how much I have left?
Of course. I think that's going to appear in the chat.
The defense has 2 minutes and 30 seconds remaining on cross-examination.
Awesome. Thank you.
Thank you. You may proceed.
Investigator Cusack, before we tackle your opinions, let's first be clear on what you did and did not do in this case. You claim that you conducted a thorough, comprehensive investigation.
That is correct.
But you were not part of the initial investigation.
I was part of the reconstruction.
I know, not the initial, correct?
I would say that is part of the initial investigation, counsel.
You did not aid in the collection of evidence.
No, however, I did take some photographs.
You simply read the reports of investigators, correct?
No, that is incorrect. I worked with the forensic team and Detective Markowitz.
Right, and by working with them, you read their reports, correct?
Yes, of course, as well as talked to them personally and visited the scene of the crime.
But reading a report will never provide a person with the same degree of understanding as being on the scene or directly examining the evidence, correct?
Correct. That is why I disagree completely with Professor Van Owen's conclusions. She read Detective Markowitz's reports and my reports. She was never at the crime scene, just like you stated.
Thank you. Again, I just want a yes or no question. You feel free to testify about your feelings about Detective Markowitz in your redirect. However, I just like a yes or no. Moving on, after reviewing other people's reports, you came to only one possible conclusion.
Yes, the evidence led to only one possible conclusion.
That the victim must have been alerted by the ring security system.
Yes.
And ultimately, the intruder stabbed the victim.
Yes, the defendant.
Moving on, I want to talk about your final assumption. To support your theory that the victim was aware the intruder was about to enter, you rely on the scuff marks found at the scene.
About to enter, no. However, the scuff marks were evidence that a struggle did occur between the defendant and the victim, Mr. Brackman.
Right, you indicate that a struggle occurred and that two individuals were a part of it, correct?
Yes, as I just stated.
Even though the evidence shows that the victim wasn't wearing any shoes.
I don't think the evidence supports that. I disagree, counsel.
Your Honor, thank you. No further questions.
Thank you. Any redirect?
Yes, Your Honor. May I inquire as to how much time I have remaining?
The
Timekeeper.
prosecution has 25 seconds remaining.
Briefly, Your Honor. Ms. Cusack, Ms. Cusack, who committed this crime based on your expert opinion in today's case and based on all of the evidence you analyzed?
Based on all of the evidence and to a reasonable degree of scientific certainty, the evidence points to Avery Becker being the perpetrator in this crime.
Thank you, Your Honor. No further questions.
Thank you, counsel.
And Your Honor, at this time, the prosecution rests, but I ask that we have a couple moments for our trial technicians to reset their clocks and get ready for the defense's case in chief.
Thank you. And timekeepers, when you're ready, please let me know.
Your Honor, as the prosecution's timekeeper, I'm ready to proceed.
Your
All right.
Honor, I'm ready as well.
Terrific. Thank you. Defense may call their first witness.
The defense calls Professor Van Owen to the stand.
Professor, you'll recall that you are still under oath.
Yes, Your Honor.
Counsel,
Good
you may
afternoon,
proceed.
Professor. Please introduce yourself. Sorry, I cut you off. Please introduce yourself to the jury by telling us your name and spell your last name for the court reporter.
My name is Blake Van Owen, Vanowen.
Before we get to know you a little bit better, let's find out why you are here today. What is your relation to this case?
I was hired by the defense to review the evidence and render an opinion as to how this crime occurred.
Before we get to your opinions, let's start by talking about your background. What do you do for a living?
I'm a private investigator, a professor, and I often testify as an expert witness in police procedures.
Tell us about your educational background.
I graduated with my bachelor's degree in English from the University of Colorado in Boulder in 2005, and about 10 years later, I got my master's degree in criminal justice from Ashford University.
That's a big gap between your bachelor's and master's degree. What did you do in between?
I became a police officer with the Aurora Police Department from about 2005 to 2006. And after I left APD, I worked in various other areas of law enforcement.
Give us some examples.
I worked as a private security guard, a school resource officer, and finally as a private investigator, which is what I do now.
You mentioned earlier that you're a professor. Tell us about that.
I currently teach a course on police procedures as an adjunct faculty member at the Community College of the Rockies. And for the past 5 years, I've also taught a course at CU Denver in police practices and social justice.
You also mentioned that you often testify as an expert witness. What areas have you testified as an expert in?
I've testified as an expert witness in the areas of use of force, false arrest, police practices, and forensic evidence techniques, as well as crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Are you compensated for your work as an expert witness?
Yes, of course. This is my career.
How much are your fees?
I charge $225 an hour for my investigation work and research, as well as $450 an hour for my time spent testifying.
What courts have you testified in as an expert?
I've testified in the U.S. District Courts in the districts of Colorado, Arizona, and Kansas, as well as the state courts in Colorado, Wyoming, Nebraska, and New Mexico.
How many times have you testified as an expert?
In over 100 cases, at least.
You mentioned before that you were hired by the defense team to render an opinion in this case. Were you able to do that?
Yes, I was.
What did you rely upon in reaching your opinions?
I relied upon the police reports, the autopsy reports, the crime scene reconstruction conducted by Kyle Cusack, as well as the cell tower reports and exhibits prepared by Detective Markowitz.
Are your opinions the products of reliable principles and methods?
Yes, they are.
And did you reliably apply those principles and methods to the facts of this case?
Yes, I did.
At this time, the defense moves to tender Professor Blake Van Owen as an expert in the field of crime scene investigation to include cell tower analysis and general police investigation tactics pursuant to Rule 702.
Any objection?
Your Honor, the people maintain that this witness does not have the qualifications necessary to opine in the broad field she has been tendered in. However, given the fact that she's been recognized as an expert by other courts, we will not object to her admission as an expert and will rather explore her concerning lack of qualifications on cross-examination.
All right, the court will recognize the professor as an expert in crime scene investigation. Please proceed, counsel.
All right, Professor, let's turn now to your investigation. What conclusions did you draw from the evidence?
I came to 3 conclusions in this case. The first, this is not a burglary gone bad. This was a premeditated and intentional murder. The second, there is no evidence tying Avery Becker to this crime. And the third, the police investigation was incomplete and therefore unreliable.
Let's talk about each of those conclusions, starting with the first. What led you to believe that this was not a burglary gone bad?
Well, one of the key pieces of investigator Kuzak's theory is that there was a struggle between the victim and the intruder based on the scuff marks found at the scene of the crime. And that's it. That is the only piece of evidence that investigator Kuzak provides for that theory.
What's the problem with that?
Well, we simply have no idea when those scuff marks were made. They could have been there 2 days, 3 days ago. Heck, they could have even been there 6 months ago. We simply have no idea when or how those marks were made.
Bear with me, Professor. Do we know if the scuffle was caused by a kerfuffle?
No, we don't.
What else led you to the conclusion that this was a premeditated murder?
The murder weapon.
What about the murder weapon?
Based on the evidence, I believe that the intruder brought the murder weapon with them.
If you believe that the intruder brought their own knife, how do you believe the victim was stabbed?
It's my opinion that the victim must have been sitting down and the intruder must have come up from behind the victim and stabbed them from behind.
How do you conclude that the intruder came up from behind the victim when we heard testimony today that says the victim was alerted by their Ring app?
Well, the prosecution assumes that the victim was alerted to the intruder entering the home because of the Ring security system sending an alert to the victim's phone. However, we have no evidence that the victim received a notification. Personally, I have a Ring doorbell and you can turn off notifications like that. Detective Markowitz has not provided any evidence as to whether or not the victim had their notifications turned on, whether the victim received such a notification, and frankly, whether the victim even had his phone on him at all.
Moving on to your second issue with Detective Markowitz's investigation, you indicate that there's no conclusive evidence tying Avery Becker to this crime. So how did the detective tie Avery Becker to this crime?
Detective Markowitz relied solely on the cell phone records of Avery Becker on March 6, 2020.
Is there a problem with that?
Yes, there are many problems with that.
Like what?
Well, first, it's important to understand that cell phone records show the possible location of a cell phone, not of a person. So for example, if you were to leave your phone in a cab and someone were to check your cell phone records for that night, it would simply show the location of the cab's route, and not you, because you were nowhere near your phone.
Was there any evidence that Miss Becker had her phone on March 6th?
No, in fact, there was evidence presented to Detective Markowitz that Avery Becker had lost her phone the day before and did not have it the day of the murder.
Even if Miss Becker had her phone on her, would you then rely on the cell phone records?
No, it's also important to understand that cell tower data is not like GPS. It's not as accurate.
What do you mean?
Well, there are 2 reasons. One, cell towers can cover very large areas. Some can cover over 100 square miles. And 2, cell phones are programmed to connect to the best tower for connection, which isn't always the closest tower to the cell phone.
So how does that affect the reliability of Detective Markowitz's opinion?
Well, assuming that Avery Becker was with her phone on the day of the murder, which we have no evidence corroborating, just because Avery Becker's cell phone connected to a certain tower does not mean that she was anywhere in the vicinity of that tower. Detective Markowitz's opinion is based solely on assumptions.
Speaking of assumptions, you also mentioned that the police investigation was incomplete. Based on your expertise, what was this investigation lacking?
Well, how much time do we have?
Keep it brief, Professor.
Well, while we're on the topic of cell phones, Detective Markowitz should have obtained a search warrant to collect and search through Alex Cifuentes' phone.
What did the detective do instead?
Detective Markowitz simply accepted a screenshot of the alleged text conversation between Avery Becker and Alex Cifuentes. Any reputable cell phone expert would know that this is unreliable.
What could the detective have done with a search of the phone?
Well, as law enforcement, there are programs that we can use to do what we call a cell phone dump, which is basically downloading the context of a cell phone, including text messages. One of these programs is called Cellbrite, which Detective Markowitz has already admitted that she has access to.
In addition to the lack of investigation into Alex Cifuentes' phone, what else did you find missing from this investigation?
A complete lack of investigation into any other possible suspects.
Well, is there any evidence of another possible suspect?
Absolutely. Even from my cursory view of the evidence, already one name stood out to me as a possible, credible suspect.
Who's that?
Blair Rollins.
Okay, tell us who Blair Rollins is.
Blair Rollins is the son of Jonathan Rollins.
And who's Jonathan Rollins?
Mackenzie Brackman was the defense attorney for Jonathan Rollins, who had been accused of murder. At the hearing, Jonathan Rollins was found guilty and sentenced to life in prison.
How does this connect to Blair Rollins?
Blair Rollins was present at the hearing, and there's also an audio recording of the hearing that I have personally listened to myself. After the sentencing, Jonathan Rollins yelled out that Brackman was going to die.
Objection, Your Honor, may I be heard?
Please.
Your Honor, this is hearsay pursuant to Rule 801, as it is an out-of-court statement being offered to prove the truth of the matter asserted. Furthermore, this is substantially more prejudicial than probative, as there is no other evidence in this case linking Blair Rollins to the crime. Therefore, using her father's words against Blair Rollins is substantially more prejudicial than probative for the jury to hear.
Counsel, any response?
Yes, Your Honor, this is not a case involving Jonathan Rollins, so it doesn't matter if it's prejudicial against Jonathan Rollins because he is not in court here today, and the jury's not deciding any verdict against Jonathan Rollins today. And again, we are not offering this for the truth of the matter, but instead for the effect on the listener, which would be Blair Rollins, his son in this case. The effect on the listener meaning that Blair Rollins heard this and then proceeded to go and take action after hearing this statement.
Any reply?
Yes, Your Honor. I'm not saying that this statement is prejudicial against Jonathan Rollins. I'm saying it is more prejudicial than probative for the jury to hear this statement and connect it to Blair Rollins, as there is no other evidence showing that Blair Rollins is involved in this case. Furthermore, this is being used to prove the truth of the matter asserted, as they are offering to show that Blair would take her father's words that she would get back at Brackman and do that very thing.
As to hearsay, the court finds that the statement is being offered actually as to the mental state of the listener and not for the truth of the matter asserted. As to 403, the court does not find that this is unfairly prejudicial, which is the standard. So the court will allow the testimony. You may proceed.
So, Professor, how does this sentencing connect to Blair Rollins?
Well, Blair Rollins was present at the hearing, and after the sentencing, Jonathan Rollins yelled out that Brackman was going to die.
So what does that mean for your investigation?
This goes to show that Blair Rollins had a much more serious motive, a much stronger, more serious motive to want to kill Mackenzie Brackman, rather than just wanting to get back on a mock trial team.
What other evidence, if anything, also pointed to Blair Rollins?
Well, for one, Blair Rollins matches the same shape and build as a suspect in the ring video. Blair Rollins was also absent from the day of school, was also absent from school on the day of the murder and does not have an alibi for the time of the murder. And even more suspiciously, Blair Rollins essentially disappeared after graduation and his whereabouts are unknown.
Yet, despite all of that, did the police ever investigate Blair Rollins?
No, they failed to do so.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Of course.
Professor Van Owen, I'd like to clarify something you said on direct examination. You said that cell towers cover up to 100 square miles?
Yes, they can cover up to.
But to be clear, that's in rural areas, isn't it?
That's correct.
And you would agree that this took place in Denver, which is a city?
That's correct, but cell towers all over can have up to those ranges.
But once again, your words were in rural areas, they can cover up to 100 square miles.
That's correct.
Now, you say there's no evidence of a struggle. You said that on direct examination, didn't you?
That's correct. The only apparent evidence is the scuff marks, which again, we have no idea when or how those were made.
Right, there are scuff marks found near the back door.
That's correct.
And there was also a broken plate found on the ground.
That's correct. I do not think that that was indicative of a struggle.
That wasn't my question. Yes, there was a broken plate.
Yes,
And there was also a chair found tipped over at the scene.
that's correct.
Now, based on your analysis, you agree a burglary occurred, don't you?
I do.
And you agree that Mr. Brackman was killed during the course of that burglary.
That is correct.
I'd like to talk about some of the things you agree with Ms. Kuzak on. You agree that the description of the blood droplets is consistent with the victim moving along towards the hallway with the knife lodged in his back. Is that right?
Correct.
And you agree that when the victim pulled the knife out of his back, that would have caused the cast off found.
Correct.
And you agree that when the knife was creating a plug in the victim's aorta.
Correct.
And that when he removed the knife, he would have bled to death rapidly.
Correct.
Where we disagree is about who committed this crime. Is that fair to say?
Yes.
And you agree that Avery Becker was absent from school on March 6, 2020, don't you?
That's correct. But as we know, she was searching for her lost phone.
Right, but she was absent.
She was.
And you agree that the cell tower reports put Avery Becker's phone near the victim's house on the day in question. Is that right?
Her cell phone records report that that it connected to those towers. I do not believe that it provides any substantial evidence that her phone was physically within the vicinity of those towers.
And you agree that Avery Becker matches the height and build of the intruder seen on the Ring doorbell videos.
Correct.
Now, you make a decent living revealing where the police have dropped the ball. Do I have that right?
That's correct.
And you like to think of yourself as a check on the power of police. Your words?
Yes.
You only worked as a police officer for 9 months back in 2005, isn't that right?
That's correct. But after I left, I worked in various other areas of law enforcement.
Right, let's talk about that a little bit. You worked as a school resource officer.
Correct.
And you never mentioned investigating burglaries or homicides in that role either. In that role, did you?
No, not in that role.
And then you worked as a private security guard.
Yes.
And once again, you never mentioned investigating burglaries or homicides in that role.
No, but like I've said, I have testified in over 100 cases as an expert witness in general police investigation tactics, forensic evidence techniques, crime scene reconstruction.
Thank you, but that wasn't my question. You didn't mention investigating burglaries or homicides in the role of private security guard, did you?
That is correct. I did not.
And then you became a professor and a private investigator, is that right?
Yes.
And that was in 2015?
Yes.
So you've been working as an expert in this field for about 6 years now?
Yes.
And during that time, you've only testified for the defense. Do I have that right?
That's correct, but that makes sense. I mean, the prosecution has law enforcement personnel at their hand with no charge. So it would make sense that, they wouldn't pay for an independent expert like me if they already have independent experts to testify for them free of charge.
So that's a yes to my question.
Yes.
Now, you would agree that there were a lot of different members of law enforcement involved in this case, wouldn't you?
Yes.
And with all the different members of law enforcement, likely hundreds of hours were spent investigating.
I cannot speak for the other.
Sorry, counsel.
I objected to calls for speculation.
Response?
Yes, Your Honor. Professor Van Owen has testified that she reviewed this case, and furthermore, she claims it was rushed. This is proper cross-examination into the bias and credibility of the witness, because if she does indeed have to speculate on how long this case took, then she doesn't really know the exact specifics of this case and therefore should not be testifying to whether it was rushed or not. But if opposing counsel is willing to agree on this, I will move on.
What?
Your Honor, I think this goes to the thoroughness of the prosecution witnesses' reports because they do not include how much time was spent on this investigation, which again, as opposing counsel pointed out, were reports that Ms. Van Owen relied upon. She cannot speculate on this time because it just simply wasn't included in the report in the first place.
It's cross-examination. The court will allow some latitude. The questions go to the witness's credibility and methodology, so the answer will stand.
Your Honor, I apologize for the interruption, but there appears to be a small time discrepancy of about 25 seconds.
Okay, thank you.
Would Your Honor like to resolve this time discrepancy and tell us what to set our timers to?
Yes, and can somebody orient me to what the discrepancy is? I can't quite make it out on the chat.
Yes, specifically the prosecution has 14 minutes and 35 seconds for the defense, but the defense only has about a little bit under than 15 minutes for the defense.
Okay. Why don't you set the clock to 14:45 remaining?
Yes, Your Honor.
Yes, Your Honor. Thank you.
Everybody got it? Are you clocks set?
Yes, Your Honor.
Okay, we're ready to proceed.
Yes, Your Honor. So, Professor Van Owen, you would agree that hundreds of hours were spent investigating this case, wouldn't you?
I cannot speculate on how much time the other investigators and Detective Markowitz have spent on this case.
Right, and even though you don't know how long they spent on this case, you still say it was rushed, don't you?
Based on the thoroughness of the evidence that and the conclusions that they have come to, yes, I believe this investigation was rushed.
And when you're rushed, you miss things. Your words?
Yes.
By the way, you charge the defense $225 per hour for any investigation work. Do I have that right?
That's correct, for my time spent investigating and writing, yes.
And you charge $450 for any court deposition and testimony.
Yes, for my time spent testifying.
So far, you've charged just under $7,000 for your investigation.
That's correct.
And you anticipate charging at least another $1,000 more for your testimony here today?
That's correct.
Your Honor, at this time, I have no further questions. However, pursuant to Rule 201, I ask the court to take judicial notice that $7,000 divided by $225 per hour is approximately 31.1 hours, spent investigating this case.
The court will take judicial notice of the math. Any redirect?
Yes, Your Honor. Professor, why is it your opinion today that this investigation was rushed?
The investigation is lacking in a lot of things. Like I've stated before, the evidence that Investigator Kuzak provides for a theory of some sort of struggle does not stand. The prosecution has failed to look into any other possible witnesses, any other possible suspects like Blair Rollins. The prosecution has overlooked a lot of credible evidence and have failed to collect evidence that might have further supported their claim. Therefore, I believe that this investigation was completely rushed and therefore unreliable.
So just to clarify, does it matter how much time the prosecution spent investigating this case?
Absolutely not.
And last question, Professor, how are cell phone records unreliable, even in a metro area?
Cell phone records, again, only show the possible location of a cell phone. And like I've said, that they're programmed to connect to the best tower for connection, which again, that isn't always the closest tower to the actual cell phone.
Thank you. No further questions.
Any recross?
Briefly, Your Honor. Now, Professor, you just said no other no other suspects were investigated. Do I have that right?
That's correct.
However, have you ever said that you relied on the reports made by Detective Markowitz and Kyle Kuzak in order to form your opinions?
That's correct.
So surely you reviewed them in enough detail to notice that Blair Rollins is listed as a suspect in Kyle Kuzak's report.
I don't recall.
Okay, no further questions, Your Honor.
Thank you. Defense, you may call your next witness.
Your Honor, the defense calls Taylor Perkins to the stand.
All right. Ms. Perkins, you'll recall you're still under oath.
Yes, Your Honor.
Counsel,
Good
you may
afternoon,
proceed.
Ms. Perkins.
Good afternoon.
Please get comfortable, and when you're ready, tell us your name and spell your last name for the court reporter.
Taylor Perkins, Perkins.
Are you currently in school, Ms. Perkins?
I am. I'm a freshman at CU Boulder.
What are you majoring in?
Communications.
And where did you go to high school? I'm sorry.
I went to Colorado High School.
When you were in high school, were you a member of the CHS mock trial team?
I was.
Great. Let's talk about your time on the mock trial team. First, who are the other members on the team?
Well, there was a group of us, which included my best friend, Avery Becker, and our coach, Mackenzie Brackman.
What was your relationship like with Coach Brackman?
It was fine. We didn't really have any issues with each other, unlike Avery and Coach.
Well, what do you mean by issues?
Coach Brackman was always giving Avery a hard time about not coming to practice prepared, or she often did do the least amount of work.
How did Coach Brackman deal with Miss Becker then?
Eventually, Coach Brackman ended up kicking Avery off the team.
How did Avery handle getting kicked off the team?
She tried to apologize to Coach Brackman over and over again, and she just really hoped to get back on the team.
And was she ever able to get back on the team, Ms. Perkins?
No, she wasn't.
Let's fast forward a bit and talk about the day before Coach Brackman was killed, March 5th, 2020. Did you see Avery Becker that day?
Yes, we basically spent the whole day together.
What did you two do?
Well, she came over to my house, and then we went to the Fry Shack, then the mall, then back to my house.
When you went to the Fry Shack, did you run into anybody that you knew?
Yes, we actually ran into the students from the mock trial team.
And did you talk to the students while you were at the Fry Shack?
Yes, we sat with Alex Fuentes, and her and Avery spoke.
Who is Alex Fuentes?
Alex is just another student from the mock trial team.
Did Avery and Alex get along?
No, it always seemed like Alex was really jealous of Avery's success on the team.
Right. Well, you mentioned that Avery and Alex spoke at the Fry Shack.
Yeah, I mean, until Avery stormed off.
What do you mean stormed off?
Well, Alex was telling Avery how upset she was that Avery got kicked off the team, but it came across as very insincere and just really passive aggressive. And obviously Avery looked upset, and then she went into the bathroom.
Now, did Alex Fuentes stay at the table?
Yes, along with Avery's phone at that time.
What did you do?
I didn't realize the phone was there, so I just got Avery and we went to the mall.
Did you go anywhere else that day?
No, just the mall, then back to my house.
Okay, let's turn now to the following day, March 6th. What did you do that morning?
Avery came over to my house to pick me up in the morning.
And where did you two go?
We were supposed to go to school, but I mentioned how I kept calling Avery over and over again and how she wasn't responding. So we realized that her phone was actually missing. So we spent the day to retrace our steps.
What do you mean, retrace your steps?
Well, we went to all the stores at the mall that we went to the previous day. And then we went to the Fry Shack, and we still couldn't locate the phone.
To your knowledge, did Miss Becker ever find her phone that day?
No, we kept calling it over and over again, and we still couldn't find it.
Now, were you with Miss Becker the whole day on March 6th?
Yes, I was.
And at any point on March 6th, did you or Miss Becker go to 444 South Flower Street?
No, we were nowhere near there.
And at any point on March 6th, did you or Miss Becker come into contact with Coach Brackman?
Not at all.
Thank you. No further questions at this time, Your Honor.
Cross-examination.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Of course.
Good evening.
Good evening.
I'd like to talk about the map Detective Markowitz testified to earlier. Your Honor, permission to display Exhibit 15 for the jury, which has previously been admitted into evidence?
Yes.
And may I publish it to the jury as well?
Yes.
Now, Ms. Perkins, when looking at this image, that's Avery Becker's house in the top shaded region, yes?
Yes.
And Mr. Brackman's home is in the bottom shaded region?
Yes.
And you heard earlier today Detective Markowitz testify to these cell towers placing Avery's phone at the scene of the crime, yes?
She never had her phone on her, so.
That
Objection.
wasn't my
This
question.
is a proper lay opinion.
Response?
Yes, Your Honor. I was simply asking Ms. Perkins if she had heard throughout the course of the trial, Detective Markowitz testify to that. This is proper cross-examination. I'm simply asking Ms. Ms. Perkins to identify the fact that she has heard Detective Markowitz testify to the fact that this is where the cell towers placed her phone.
All right. You can ask that question. You may proceed.
So that's a yes to my question, Ms. Perkins. You heard Detective Markowitz testify to cell towers placing Avery's phone at the scene of the crime.
That's correct, yes.
Now, you during direct examination, you testified to being at the Fry Shack and the mall with the defendant. Am I remembering that correctly?
Yes.
But when looking at this map, neither the Fry Shack or the mall are in any of the red shaded regions, are they?
No, they're not labeled on the map.
Well, thank you. This exhibit is no longer needed. Your Honor, permission to publish Exhibit 14 for the jury?
It's previously admitted, I believe.
Yes, Your Honor.
Yes.
Now, Ms. Perkins, it's true that after Avery Becker got kicked off the team, the two of you thought of ways for her to get back on?
Well, yeah, she just texted everyone on the team. I didn't really come up with a way with her. She just wanted to get back on the team.
That's right. And the defendant even texted Alex Cifuentes. Isn't that also true?
I honestly have no idea. I assumed that she texted the whole team, but I even thought that that would have been weird because they didn't get along. But it was a long time ago, and I really don't remember if she did, but I just assumed.
Have you ever said, I think she even texted Alex Cifuentes, yes or no?
Right, I just said I assumed that she texted her, but I really don't know.
Now, when looking at this exhibit, that's Avery's name in the top shaded region, yes?
Yes.
And the person labeled first says, hey, Alex, it's Avery. Am I reading that right?
Yes.
And just as you thought or assumed, the person labeled first in this text message chain then asked for help to get back on the mock trial team, don't they?
Yeah, I guess, yes. They asked to get back on the team, yeah.
Thank you. That exhibit is no longer needed. Now, I'd like to talk to you about, we've talked about the map, we've talked about the messages. Now, I'd like to talk to you about the motive to the best of your knowledge. Now, while you were on the mock trial team, the defendant and Mr. Brackman didn't get along, isn't that right?
No, they did not.
They even had a feud?
Yes.
And the feud bothered the defendant, didn't it?
I mean, yeah, she was obviously upset about it.
Enough to play pranks, isn't that true?
Yeah, just small little ones.
Now, you would agree that the victim, Mr. Brackman, was mean to the defendant, yes?
Yes.
He was always on her about something, as you said during direct examination?
Yes, he was.
But a couple days before Mr. Brackman was killed, Avery Becker vandalized his property, the Porsche, yes?
Right, and it was a complete accident. She really thought it was a temporary marker, and it was just a complete crazy thing that she did. She really didn't mean it.
Your Honor, may I be heard?
Please.
Your Honor, I object non-responsive. I asked the witness a properly framed yes or no question, which was a few days before Mackenzie Brackman died, she vandalized his car, the Porsche. That implies a yes or no answer that she did or didn't do that. The witness has gone far beyond that. I'd like everyone to remember that this is a timed competition, and if Ms. Perkins would like to go over this, they may do so on their own time during redirect examination. I ask that you construct the witness to answer the question to the briefest possibility.
Any response?
Your Honor, I believe that the witness did in fact answer the question and was further explaining her answer. The witness is not forced to answer yes or no. She clearly answered a question and further elaborated upon that, and that is appropriate in this case. I understand that this is a timed trial, but that does not matter in the fact that she needed further elaboration.
The witness will respond to the question if explanation is needed. So indicate without necessarily volunteering it. I think you understand the questions are focused on cross-examination. With that, counsel, you can proceed.
Your Honor, I asked that in regards to this question, everything said after the word yes be strict from the record.
The court will strike that additional answer.
Now, Ms. Perkins, after the defendant was kicked off the team, we already established that the two of you tried to get back on, right?
Only she did. I was already on the team.
Well, Ms. Perkins, you helped her get back on the team, yes or no?
Yes, but you said that the two of us tried to get back on, but I was on the team and she wasn't.
My apologies, Ms. Perkins. Now, Avery Becker tried to get back on the team the day before Mackenzie Brackman was killed. Isn't that true?
Yes, she was just hoping to get back on the team.
But Mr. Brackman never changed his mind, did he?
No, he didn't.
And the next day he died, isn't that right?
Yes, unfortunately.
Now, I'd like to briefly finish off by talking about the Fry Shack the night of March 5th. You testified to having seen the phone next to Alex Cifuentes on that night, yes or no?
Yes.
But Ms. Perkins, you would agree that nowhere in your affidavit do you mention seeing Alex touch Avery's phone, do you?
We left the phone there, so I don't know what Alex did after we left.
So that's a yes to my question. Nowhere in your affidavit do you mention seeing Alex touch Avery's phone.
Right, we weren't there the whole time, so no.
And again, nowhere in your affidavit do you mention seeing Avery needing to use Avery's phone, do you?
I don't really understand that question. It was Avery's phone.
Let me clarify for you. Nowhere in your affidavit, Ms. Perkins, do you mention Alex saying she needed to use the defendant's phone, yes or no?
No, I don't recall.
And you knew you had an obligation to update your affidavit with any new or relevant information prior to trial today, yes or no?
Yes, I don't have any updates.
And yet it's nowhere in there.
Right, I don't have any updates to my affidavit. Everything stands.
Thank you, Your Honor. I have no further questions at this time.
Any redirect?
Yes, Your Honor, briefly. Ms. Perkins, I just wanted to give you a chance to elaborate and not be interrupted. Avery Becker did like to play some little pranks here and there.
Yes, they were very small.
And did she intentionally mean to write on the car with a permanent marker?
No, of course not. She would never do something like that. She truly thought it was a temporary marker. And when she found it as a permanent marker, she apologized over and over again. And she offered to get a job to pay for it. She offered to do everything she possibly could. It was just a big misunderstanding.
Perfect. Thank you for your response. No further questions, Your Honor.
Any recross?
No, Your Honor.
All right. Defense may call the next witness.
Yes, Your Honor. The defense calls Avery Becker to the stand.
Ms. Becker, you'll recall that you are still under oath. Counsel, you may proceed.
Good afternoon, Ms. Becker.
Good afternoon.
Tell us your first and last name and spell your last name for the court reporter.
My name is Avery Becker, Becker.
Now, before we get into the details of this case, let's address the question on everyone's mind. Did you break into Mackenzie Brackman's home?
No.
Did you ever physically assault Mackenzie Brackman?
No.
And Ms. Becker, did you kill Mackenzie Brackman?
Absolutely not.
Now that we've gotten that out of the way, let's learn more about you and your relationship with Coach Brackman. How do you know Mackenzie Brackman?
I was a part of the Colorado High School mock trial team for the last 4 years, and Coach Brackman was our coach.
What was your relationship like?
It wasn't always easygoing. We didn't always get along.
How so?
Well, we tended to argue a lot, and he didn't really agree with how I did mock trial. He didn't think I worked hard enough, that I was lazy, which I disagreed with.
Were you always at each other's throats?
I wouldn't say always. I mean, through mock trial, I was able to achieve a lot of success, and it's something that I will always cherish.
Did you hate Coach Brackman?
We had our disagreements. I don't think he liked me very much, but I didn't hate him. And I really can't believe that he's gone.
Did these disagreements ever come to a head?
I would say they probably did about right after the regional mock trial tournament.
What happened?
Well, at the tournament, I had won an award for best attorney, and I also had won an award for closing. But to do that, I pretty much had to go off script, which is not what Coach Brackman wanted me to do. So I had to go against what he wanted me to do during trial.
How did Coach Brackman handle that?
Well, the practice after regionals, he really laid into me about how I didn't follow the script, how I was lazy. I pretty much got it by luck. But what bothered me most was that he said that I only relied on my good looks to get those awards.
Why did that bother you the most?
It was just a really uncomfortable comment made by an adult male to a female student like myself that made me feel unvalidated, and it was just uncomfortable.
How did you handle that, having your coach tell you these things?
Well, I was really tired of being insulted, so I left practice.
What happened when you left?
I went out to the parking lot and I had a dry erase marker in my hand from practice, and I saw his car in the parking lot, and I wrote on the hood, "Worst Attorney Award." Come to find out, it was actually a permanent marker. It was by far the dumbest thing I've ever done in my life, and I feel awful.
How did Coach Brackman find out about his car?
Well, after I was done writing on his car, I turned around and he was walking up behind me, and he just exploded.
What do you mean by exploded?
Well, he was really angry, really upset, and he was yelling at me.
What did he say?
"What the hell have you done to my car? That's it. You're off the mock trial team."
How did you respond?
Well, I was really ashamed, and I went home to my mom, and I cried and cried. I couldn't believe I was just kicked off of the mock trial team.
Did talking to your mom help?
Yeah, it really gave me the chance to calm down, to clear my head a little bit, and I realized through talking to her that apologizing was the best course of action to take. So I decided to go to his office the next morning to apologize.
How did he take your apology?
Well, when I got to his office, his secretary said that he was busy. So then I tried texting him. I offered to pay to repaint his car, to scrub it all off.
Did Coach Brackman ever respond?
No, he didn't. I was devastated
Why were you devastated?
because I never got the chance to truly apologize before he was killed.
Well, speaking of the murder of Coach Brackman, let's talk about your whereabouts that day. Where were you on March 6th?
I was with my friend Taylor Perkins the entire day.
What did you and Miss Perkins do all day?
So that morning I realized that I didn't have my phone. So we decided to skip school and look for it.
How did you look for it?
Well, the last time I remember having it was at the Fry Shack. So we decided to retrace our steps. We went to the Fry Shack, the mall. We tried calling it, but just kept going to voicemail.
Did you at any point go to Coach Brackman's house on March 6th?
Not to my knowledge. I don't even know where he lives. And also, I was busy looking for my phone the whole day.
Ms. Becker, you've been sitting here throughout the entire trial, and you've heard testimony from all the witnesses. Now, one of those witnesses, Alex Cifuentes, is claiming that you texted them that you planned to go to Coach Brackman's house to trash it. Did that happen?
No, I never sent any of those text messages.
Did you want to get back at Coach Brackman?
Initially, I think I said something along the lines of that to my mom, but that was more the heat of the moment, and I meant that more of like an embarrass him kind of thing, like prank call him or something like that. But even then, those feelings changed.
What do you mean your feelings changed?
Well, mock trial meant everything to me, and the only way of getting back on the mock trial team was to get in Coach Brackman's good graces, and I wouldn't do anything to jeopardize that.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Before I begin, may I inquire as to how much time I have remaining?
Timekeepers.
The prosecution has 7 minutes and 56 seconds remaining.
Your Honor, I have 7 minutes and 55 seconds.
Okay, we'll go with that.
Before I begin, can Your Honor see and hear me all right?
Yes, thank you. You may proceed.
Ms. Becker, first I'd like to talk about something you said on direct examination. You claimed to be devastated about not being able to apologize for what you did to Mr. Brackman. Isn't that right?
Yes,
However, you also said that Mr. Brackman had a massive ego, didn't you?
he did.
And you even went so far as to call him a joke, right?
He was.
And you said these things in your affidavit, which was after Mr. Brackman was murdered. Do I understand that correctly?
Yes.
Now, I'd like to talk about your motive. It's fair to say that you and Mr. Brackman didn't have the best relationship, did you?
No, we didn't.
You argued at almost every practice.
Yes.
That is, until you were kicked off the team only 3 days before Mr. Brackman was murdered. Isn't that right?
I'm sorry. Can you clarify your question, please?
Of course. You were kicked off the mock trial team on Tuesday.
I think so, yes.
Mr. Brackman was murdered on Friday, March 6th of 2020, correct?
Yes.
So that's 3 days before Mr. Brackman was murdered?
Yes.
As you said on direct examination, you were kicked off the team for vandalizing Mr. Brackman's car with a permanent marker. Isn't that right?
It was meant to be dry erase, and I did write on it. That's why you kicked me off, yes.
But that's a yes to my question. You vandalized it with a permanent marker?
I don't know if it's considered vandalizing, I assume, but yes.
Getting kicked off the team made you angry, didn't it?
Yes.
So angry, in fact, that you told your mother that you would get back at Brackman if it was the last thing you did. Isn't that right?
I said that, yes.
And despite what you said on direct examination, nowhere in your affidavit do you clarify what you meant by that statement, do you?
I'm sorry. Can you clarify your question? I'm a little confused.
Of course, Ms. Becker. Despite the statements that you made on direct examination about what you meant by your statement that you would get back at Brackman if it was the last thing you did, you didn't include anything about what you meant by that statement in your affidavit, did you?
Well, I don't mean murder. I'm if that's what you're getting at, I don't, but I guess I don't explicitly, I just talked about how I embarrassed him and pranked him, but.
So that's a yes to my question, Ms. Becker?
Yes.
And you knew you had the obligation to update this affidavit with any new or relevant information up until the day of trial?
Yes.
Now, let's talk about the investigation. You saw the Ring doorbell videos earlier today, isn't that right?
I did.
And we can agree that you matched the height and build of the person in those Ring videos?
Yes.
We can also agree that you skipped school on March 6th of 2020, can't we?
I did.
We agree that you and Miss Perkins are best friends?
Yeah, I love Taylor.
Now let's talk about the map that Detective Markowitz talked about earlier. May I have permission to publish Exhibit 16 to the jury, which has previously been admitted into evidence?
It's already in evidence, yes.
Ms. Becker, can we agree that your phone was in the same area as your house in the top shaded region of this map?
For when?
1247.
On when?
On March 6th of 2020, as Detective Markowitz talked about earlier, Ms. Becker.
Oh, March 6th? I didn't have my phone on March 6th. So I don't know where it was.
That's not what I asked you. If you look at this map, your house is labeled at the top, correct?
Yes.
And your house is in the red shaded region, the top red shaded region in this map, isn't that right?
Sure.
Thank you. The exhibit is no longer needed. Now, I'd like to talk about the messages. We can agree that you attempted to get back on the mock trial team, isn't that right?
Yeah.
May I have permission to publish Exhibit 14 to the jury, which has previously been admitted into evidence?
It's already in evidence. You can display it.
Ms. Becker, that is your name at the top of the screen, correct?
Yes, my name is Avery.
And the person labeled as Avery Becker asks for help to get back on the mock trial team in these texts, don't they?
I've never seen these texts until today, so I don't really know what it all says. I haven't had a chance to read them all.
As you heard Ms. Cifuentes testify to earlier, the second text from the person labeled Avery Becker asks for help to get back on the mock trial team, yes or no?
Yes, it looks as though it appears that the text in question is asking, is there a way to get back on the team?
Thank you. The exhibit is no longer needed. Now, I know you claim to have lost your phone, but let's talk about that a little bit. You claim to have lost it at the Fry Shack on March 5th of 2020, isn't that right?
Yes, I think at least.
However, after the Fry Shack, you went to the mall, didn't you?
The Fry Shack is like near the mall, so it kind of like the same thing.
So that's a yes to my question?
I think so.
And at no point during that time did you realize your phone was missing, isn't that right?
For when?
When you were at the mall on March 5th of 2020, Ms. Becker.
I just didn't notice my phone was missing.
Thank you, Your Honor. I have no further questions at this time.
Thank you, counsel. Redirect.
Yes, Your Honor, a brief redirect. Ms. Becker, what did you mean by when you said that you wanted to get back on the team?
Well, I wanted to get back on the team after I had been previously kicked off, but it ended up being okay because Taylor was really nice enough and she gave me her spot.
Now, in our cross-examination, we saw some questions about the text messages. Have you ever seen those text messages before?
Not until today, and I've never sent those. I wouldn't even text Alex in the first place.
And finally, one last question. We also heard that you said that you'd get back at Coach Brackman if it was the last thing you did. What exactly did you mean by that?
I just meant that as something like embarrass him, or I don't know. I never meant to kill him, and that's not what that meant. And yeah, like I said, even those feelings changed.
Thank you. No further questions, Your Honor.
All right. I don't believe there's time remaining for any recross.
That's correct, Your Honor.
Okay. I believe that's the last defense witness. Is that right?
Yes, Your Honor, the defense rests.
All right. Thank you. We'll move to closing arguments.
Yes, Your Honor, I have a closing argument.
You may proceed when you are ready. And timekeepers, can you tell me how much time is allotted?
Your Honor, the prosecution and defense both have 5 minutes. However, the prosecution has reserved all of their remaining time for rebuttal.
Okay, thank you. And at the conclusion, if you can let me know what remains, that would be great. Thank you.
Yes, Your Honor.
Your Honor, before I begin, I have a request to make for the court.
Okay, let me know.
I ask that during the course of my closing argument, my trial technician be allowed to display pieces of evidence that I'll be discussing that we've already admitted into evidence and that we've already sought to publish. In particular, I'll be discussing Exhibit 14 and Exhibit 16, and I ask permission for my trial technician to display those exhibits for the jury during the course of my closing argument. I also ask that jury instructions 7, 8, and 9 also be displayed on the screen as I'll be discussing those as well.
That's acceptable, and as all parties will recall, the court has constructively instructed prior to this point, so that's appropriate. You can proceed whenever you're ready, counsel.
Yes, Your Honor. May it please the court. You can hide your face behind a mask, but you cannot hide the truth. And the truth is in the map, the messages, and the motive. The prosecution and defense agree on a lot today. We all agree that a burglary happened. We all agree that during said burglary, Mackenzie Brackman was killed. And we all agree that a person wearing a mask and matching the size and build of the defendant is the one who committed these crimes. The only dispute here today is over who wore that mask. But members of the jury, that mask cannot hide the truth, because the truth is in the map, the messages, and the motive. The map. Detective Markowitz showed you with Exhibit 16 the route taken from Avery Becker's house to the home of the victim. The detective explained how cell towers tracked Avery Becker along this route, placing her at the scene of the crime at the time of the burglary and murder. The messages. You saw the text messages sent from Avery Becker to Alex Fuentes. Texts that expose the bitter truth of Avery Becker's intent. Let's hear those texts again. Well, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. And that's exactly what Avery Becker did. She waited until she thought Mr. Brackman was at work, broke in with the intent to do damage, and then stabbed Mr. Brackman with the very knife he used to defend himself. The motive. As we heard time and time again today, Avery Becker and Mr. Brackman have had a history of petty fights and low blows, escalating to the vandalization of his 1986 Porsche. Failed attempt after failed attempt to get herself back on the team made Avery Becker angrier than she'd ever been before. So she put on the one thing she thought would hide herself, a mask, and made a promise that she would get back at Brackman if it's the last thing she did. And she followed up on those words. As she said in her direct examination, she never meant to kill him. Now, as the prosecution in today's case, we've charged the defendant with 2 crimes, murder in the first degree and second-degree burglary. But in order to understand murder in the first degree, it's helpful to talk about second-degree burglary. So let's do that. Jury instruction 8, which is displayed for you now, spells out the crime of criminal mischief, the very crime the defendant intended to commit when the defendant entered Mackenzie Brackman's home. Jury instruction 9 spells out the crime of criminal mischief, the very crime the defendant intended to commit. So when you put it all together, we've proven the defendant is guilty of second-degree burglary because Avery Becker entered Mr. Brackman's residence without permission and with the intent to cause damage to his property. So again, it doesn't matter whether the crime of criminal mischief was committed. Avery Becker was guilty of second-degree burglary the moment she stepped into Mr. Brackman's home on March 6th. But now let's talk about murder. Jury instruction 7 indicates the elements of murder in the first degree. It says Avery Becker committed this crime if Mackenzie Brackman died as a result of a burglary on March 6th. Members of the jury, the defense's own theory is that Mackenzie Brackman died as a result on the home invasion on March 6th. So the only question remaining for you is over who wore that mask. That mask cannot hide the truth. You know it was Avery Becker behind that mask because we showed you the map, we showed you the messages, and we showed you the motive. Find the defendant, Avery Becker, guilty. Thank you.
Timekeepers, how much has prosecution reserved?
Your Honor, I have 55 seconds remaining.
Consensus on that?
Yes, Your Honor.
Great. Thank you. Closing for the defense.
Avery Becker is not guilty. The prosecution brought forth 2 charges in today's case: burglary in the 2nd degree and murder in the 1st degree. In bringing forth those 2 very serious charges, the prosecution accepts the burden of proof. To prove this case and the facts of this case beyond a reasonable doubt, the prosecution has not met their burden, and they know it. Let's talk about the 3 things that they have to prove this case: the map, the messages, and the motive, and how they did not prove these elements. Start with the map. The prosecution continues to tell you that the map places Avery Becker at the scene of the crime at the time of the murder. There's a very important problem with that statement. They cannot tell you when this crime occurred. Scene of the crime, time of the murder. But they cannot tell you when this crime occurred. So how can they hold Avery Becker accountable for her location when they cannot tell you where she was supposed to be and when she was supposed to be there? Their lead detective left this information out of their case. Their lead detective cannot tell you a timeline for this case. Instead, what their lead detective did was assumed that Avery Becker was at the scene of the crime because of the time that her cell phone went off. Instead of starting with the facts of when the murder happened, they assumed Avery Becker was guilty and then applied those facts to her through the CDR records. Putting aside the fact that those CDR records are not reliable, as you've heard from 3 witnesses, they are nothing like GPS, and they also cannot tell you where a person is at the time. They can only tell you where that cell phone is. And you heard Avery Becker testify that she did not have her cell phone on March 6th. You also heard testimony that these cell phone records are unreliable. Now, let's talk about those text messages that establish the motive for Avery Becker. These text messages are integral to the prosecution case. They're so important. This was the launching pad for the prosecution's case against Avery Becker. So instead of asking for the cell phone, getting a warrant for Alex Cifuentes' cell phone, and then running a report on that cell phone using a system called Cellbrite that the police force both had access to, and that their lead detective had the training to do, they simply asked a 17-year-old to send screenshots of one of the most important pieces of evidence in their case to the detective. They didn't even ask the Alex Cifuentes what phone number the contact that they assigned Avery Becker to was. Avery Becker did not send those texts today. Those texts are not reliable pieces of information. Those texts are screenshots provided to you by a 17-year-old, and the prosecution is hinging their case on those screenshots. That is absurd. Let's talk about this motive. Avery Becker wanted to get back on the mock trial team. She can't do that if her coach is dead. Avery Becker told you that she would do anything to get back into Coach Brackman's good graces. That does not involve murder. That does not involve breaking into the house. What the prosecution is asking you to do today is unreasonable. They're asking you to take a leap from high school mock trial drama to murder. Their investigation is woefully lacking. You heard from their lead detective that her report is not thorough. You heard that if she included all of the pieces of evidence that she found in this report, that her report would be pages and pages long. So she spared us from reading pages and pages of evidence that could potentially exonerate Avery Becker or point us to another suspect in this case that is credible. Even evidence that could tie Avery Becker to the scene. Here's why that's a problem. We learned in court for the first time ever today that the prosecution detectives ran tests for DNA, for fingerprints, and for blood at the scene of the crime. That is the first time we have ever heard that piece of information. Those tests are mentioned nowhere in their lead investigator's report. That's a problem. We also heard that the suspect Blair Rollins is mentioned in her report. We don't know what steps Detective Markowitz took to investigate Blair Rollins. We don't know what information she found out about Blair Rollins. That's a problem. Detective Markowitz cut corners in this investigation. The prosecution has not met their burden of proof. This investigation was rushed. This was a rushed investigation. This was a rush to judgment. Ladies and gentlemen of the jury, it is your turn to make this a rush to justice. Find Avery Becker not guilty and tell the prosecution to go back out there. Tell the police department to go back out there and find the actual killer that the facts point to. Tell them to find actual facts that lead to a suspect. Avery Becker is not guilty.
Thank you, counsel. Counsel for prosecution, you have 55 seconds reserved for rebuttal.
Yes, Your Honor. And can you hear and see me all right?
I can.
Now, opposing counsel talked a lot about a sloppy investigation, but no one conducted a more sloppy investigation than that of Professor Van Owen. Opposing counsel talked about how Miss Van Owen is the check on police. However, only Detective Markowitz and Kyle Kuzak were the ones who went to the scene of the crime. And as opposing counsel stated, checking reports is not nearly enough information to understand the crime scene as it is when you actually go there. And while we're on the topic of Professor Van Owen, the one who's supposed to check the work of the police didn't even know how long we spent working on this crime. She has no evidence, and if you want to talk about a sloppy investigation, she is the one who has to be held accountable. Find the defendant, Avery Becker, guilty. Thank you.
Thank you, counsel. The case is now submitted to the panelists for their scoring and resolution.
I believe we have all of the scoring panelists' score sheets, so if you want to do comments, you can start that now.
Terrific. Thank you, everybody. I'll turn it over to any of the scoring panelists that have any comments that they would like to share.
I can go ahead and get us started. Hi, everyone. I'm Caitlin Turner. I was most recently the elected DA in the 11th Judicial District, so I'm a prosecutor. I want to congratulate you all on the good work that you did today. Everyone did very good. I can tell that you have a very good handle on the facts in the case and that you're all well prepared. So I want you all to feel good about the work that you've done so far. I'll just give a few comments. I took notes throughout, but I know we want to be brief in our feedback. On opening statements, I thought both teams did a really good job. Hannah, you did a really good job laying out your theme with the map, messages, and motive. It's good to start with a theme that tells the jury kind of what they should be looking for in the evidence that's going to come. It's helpful to frame the trial like that for a jury, because they don't know anything about the case when they get started. So I always think that's nice when counsel can give the jury kind of an idea of what should I be listening for. I thought you did a really nice job with that. And also, I really appreciate when you mentioned finding justice for the victim. As a prosecutor, that's always something that I carried into the courtroom, whether we were at trial or even just an emotions hearing. The victim is really who you're fighting for. They're the face to the case. They're who the jury is going to connect with. I thought you did a nice job with that. Jacob, on your opening, you did a really good job talking about questions that are going to go unanswered. That's another great way to frame it for the jury to know what gaps am I going to be looking for. These are the questions that the attorney is telling me aren't going to go answered or are going to go unanswered. So I'm going to listen for that when I hear the testimony. And I thought you also did a good job talking about the unreasonable leaps that you believe the prosecution was going to ask the jury to make. And you did a really good job of reminding the jury of the prosecution's burden, because of course, prosecution is a very high burden in a criminal case. And beyond a reasonable doubt is not something that's going to be easy to reach with the fact pattern that you all had here. So I appreciated your work there. Let's see here on direct. Hannah, I thought your direct was good. You had a good pace of questioning. Grant, you did a good job when you asked your witness to give yes or no answers. That's always tough to do on cross when, of course, it's what you want. And I thought you were effective in asking the witness, hey, I'm just asking for a yes or no. You weren't abrasive in it. And sometimes that's enough just to get the witness to be a little more cooperative and not giving such a long narrative response. Amanda, on your cross, I thought you did a really good job when you walked the witness down the path of impeaching her on the DNA evidence. That was really nice. And you also did really well talking about the phone records and the time the 911 call came in, because of course you would expect your investigator to have that information. That would have been crucial information, and you did a good job eliciting that they hadn't put that in the reports. They weren't able to answer those questions. Let's see here. Anna, your direct was good. I didn't have any specific critiques. Annika, your direct was also well done. Jacob, I would say you did well. The one thing I would caution you about is you tended to kind of rock back and forth. And it just caught my eye while I was watching. So, and it's much more noticeable on video, of course, than it would be in real life. But just something to keep in mind that you want to try to not, because it's distracting, but nothing to do with the substance of your good work. Let's see what else. Then we got to the defense. I thought everyone did well with your witnesses there. Several of you, and I can't even tell you if it was one team or both teams, but when you were asking for permission to publish a piece of evidence that had already been admitted, and I think the judge was kind and gentle in telling you, hey, it's already been admitted, you can go ahead and show that to the jury, but you don't have to ask for permission to publish an exhibit that's already been entered. You can just say, hey, I'd like, here is this exhibit. Closings were good. Annika, you went back to that theme that your team had, that we had come from the opening, which tied it together, which was very nice. And that can be helpful for the jury too, to remind them, hey, I started with this theme and I'm going to go back to it. And hopefully you remembered my theme throughout all the testimony, and you can see that we held with our theme, and we showed you everything we needed to show you. And Amanda, you did a good job talking about the holes in the investigation, and also going back to your team's theme with the leaps that that the prosecution expected. And I think you did a nice job with that. This leap from high school mock trial drama to murder, that is a pretty big leap. And I think you did a good job highlighting that. So thank you all for your work. I was really enjoyed watching your trial today.
I'll go ahead and piggyback off of that. And thank you so much, Caitlin, for being so thorough there. So I'm going to just adopt everything that she just said, because that was amazing feedback. And I agree that I was just so impressed with everything that you guys had to say. I am also in litigation. I don't do criminal work. I'm a civil litigator at Hall & Evans. And so my work is a little bit different, but I also do trials. And I was really impressed with your guys' use of objections and the way that you guys didn't back down when somebody did object to something. That is certainly something that is so different than even from like the regional tournaments I know that I saw at least one of these teams in the regional tournaments, and this is even from that regional tournament, you guys have come leaps and bounds from then. So wow, great job. And just really congratulations for making it this far, especially in these really bizarre circumstances. I know it must be so weird for you not to be able to all be in the same courtroom and having your coach and your parents and your teammates all there with you, and instead be working from home and trying to present this trial from your home offices and your bedrooms or from your schools. But congratulations, you were all so professional. You guys did a great job. I certainly would not have been brave enough to do this when I was in high school. I hardly feel like I'm brave enough to do it now. But congratulations, fantastic job. I'm really proud of you all.
I mean, yeah, just to follow up what everybody else said, I think you guys did great. I'm actually not a practicing attorney, but I'm graduating from DU Law this semester. I think one thing that you guys did really well was making sure that us, the scoring panelists and the judge, could see you and hear you, which is definitely something that's really important over Zoom. I mean, I've had teachers who talk for 10, 15 minutes and don't realize they're muted the entire time. So I definitely think that's a good step, but you guys had great, strong closing statements and opening statements, and just in general, you guys did really good.
And I am also, like Ariana, a civil defense practitioner, not actually a judge, but tried enough cases that I can probably fake it, I hope. This was an incredibly enjoyable experience. There were really solid objections that were being made. Jacob, keep up with those, the 702 objections. The one you made as to scope in a real trial, I probably would have sustained that. That was that was sharp. Hannah, you are an absolute knife. I love your style, and Jacob, I think you've got a future in radio. You are smooth. The tone is spectacular. I thought the enunciation which is something that a lot of trial attorneys really struggle with. I mean, and you guys have been through this fact pattern plenty at this point, but there is always a tendency and a temptation to rush and let your pacing get out in front of you. All of you, I think, controlled that instinct very, very well. Witnesses especially maintain their tone to both sides, and that's critically important. So I think you're well on your way to mastery of the subject matter. So well done to all of you.
And I'm the state coordinator for the CBA, and I just wanted to thank you guys. Teams, you are fantastic. Volunteers, thank you, thank you, thank you. We could never do this without you guys. We appreciate all of your time, and it means a lot to all of us. So thank you.
Thanks, everyone. Good luck going forward.
Thank you.
Thank you all so much.
Thank you.
Thank you so much for your time today.
Take care now. Bye-bye.